take this opportunity to deny any prior knowledge of the Watergate break-in or participation in the formulation of any planned conspiracy to cover up that incident or acts of campaign sabotage or unethical activity. My actions in the period immediately following the break-in, which involved the raising of funds to provide for the legal defense of the Watergate defendants and for the support of their families, were prompted in the belief that such was proper and necessary to discharge what I assumed to be a moral obligation that had arisen in some manner unknown to me by reason of earlier events. The fact that I had been directed to undertake these actions by the number 2 and number 3 men on the White House staff made it absolutely incomprehensible to me that my actions in this regard could have been regarded in any way as improper or unethical.
In the Senate of the United States, a resolution to establish a select committee of the Senate to conduct an investigation and study of the extent, if any, to which illegal, improper, or unethical activities were engaged in by any persons, acting individually or in combination with others, in the presidential election of 1972, or any campaign, canvass, or other activity related to it.
From Washington, NPAC brings you gavel-to-gavel videotape coverage of today's hearings by the Senate Select Committee on Presidential Campaign Activities. Here is NPAC senior correspondent Robert McNeil.
Good evening. Herbert Kalmbach, the President Nixon's personal attorney, fundraiser, and admitted bagman for Watergate hush money, was billed as the star witness today. But before he came on, the hearings were rocked by a mere 45 minutes of laconic testimony by a man no one had heard of before. He is Alexander Butterfield, until recently a presidential assistant in charge of administration. Butterfield revealed that all of President Nixon's conversations in his 2 White House offices have been tape recorded for the past 2 years, and so have his office phone conversations. The stunned Irvin Committee, which discovered this fact only last Friday, immediately began planning to demand the tapes of crucial Watergate-related conversations. Those tapes could settle once and for all how much the president knew and when. Standing alone, Herbert Kalmbach, who followed Butterfield, would have sounded pretty sensational himself. He spelled out in great detail how, on White House instructions, he secured the money to pay off the Watergate 7.
Of today's testimony came without trumpets or flashing lights. It came instead in flat monotones as Minority Counsel Fred Thompson put terse questions to Butterfield.
Mr. Butterfield, are you aware of the installation of any listening devices in the Oval Office of the President?
I was aware of listening devices. Yes, sir.
When were those devices placed in the Oval Office?
Approximately the summer of 1970. I cannot begin to recall the precise date. My guess, Mr. Thompson, is that the installation was made between, and this is a very rough guess, April or May of 1970 and perhaps the end of the summer or early fall 1970.
Are you aware of any devices that were installed in the Executive Office Building office of the President?
Yes, sir, at that time.
Were they installed at the same time?
They were installed at the same time.
The listening devices, Butterfield said, were automatically triggered every time the President had a conversation in either office. There are conflicting claims tonight over whether this administration is the first to employ recorders in the Oval Office, but Committee Vice Chairman Howard Baker, its ranking Republican, says that's irrelevant. The most important thing, Baker says, is the tapes themselves.
It's really very, very important, new information.
Well, if
it's something we very, very badly need access to, and it's my judgment that the committee will meet in executive session probably on Wednesday morning to try to formulate a formal request for the relevant portions of those tapes that bear on the matters in controversy before this committee.
Well, if this is true, and you've been constantly looking for a way out between the President's version and the committee's attempt to reconcile these differences, would these tapes then, if it does provide the President's defense, would these tapes possibly be the way out that you've been looking so long for?
Well, let me take issue a little with looking for a way out. What I've been trying to find is additional information that bears on the subject matter in controversy. And I've been heretofore calling on the President to make available to us some information about his perception of these conversations or his special knowledge. Well, obviously the tapes are ready-made for that. The tapes are extraordinarily important in that respect, and I'm not going to even guess what the White House response will be if we request the tapes, but I am going to request that we will.
Here is NPAC's nightly preview of the testimony. It begins with Richard Moore on the stand. In the first hour, he says John Dean described his role as innocent participation, and Moore says the President had his reasons for saying he had full confidence in Dean, even after the counsel admitted he'd been deeply involved in the Watergate cover-up. Butterfield testifies in the second hour. He tells of the recording devices in the Oval Office and elsewhere and explains which 4 presidential telephones were rigged for recording. In the third hour, Butterfield explains that the recording system was a secret and no one was to know about it. He says he thinks the tapes were to be used in the President's defense and that he hopes his testimony won't damage that defense. Former presidential lawyer Herbert Kalmbach takes the stand in the fourth hour, saying that John Ehrlichman told him to go forward with the fundraising plans to provide money for the Watergate 7. And Kalmbach adds, Ehrlichman said the effort must be a secret because if the press found out, our heads would be in their laps. Ehrlichman feared that the press would misinterpret what was being done. And the hearing opens with Chairman Irvin dropping his gavel.
Some have asked what the objectives, what the power and objectives of the Senate Select Committee on Presidential Campaign Activities are. I have never found a finer statement in respect to the desirability, yea, the necessity of congressional investigations than that made by then Congressman Richard M. Nixon, or rather than that made by Richard M. Nixon in relation to his activities as a congressman holding membership on the Un-American Activities Committee of the House, with particular reference to the investigation into the Hiss Whittaker Chambers affair. This statement appears in the chapter entitled Politics with Honor in his 6 Crises, and I read it. Despite its vulnerabilities, I strongly believe that the committee serves several necessary and vital purposes. Woodrow Wilson once said that congressional investigating committees have 3 legitimate functions. First, to investigate for the purpose of determining what laws should be enacted. Second, to serve as a watchdog on the actions of the executive branch of the government, exposing inefficiency and corruption. Third, and in Wilson's view, probably most important, to inform the public of great national and international issues. I had served on the committee long enough to realize that congressional investigations of communist activities were essential to further all these purposes. I knew that if the committee failed to follow through on the Hiss case, the effectiveness of all congressional investigations, in particular those in the field of communist activities, might be impaired for years. But more important by far than the fate of the committee, the national interest required that this investigation go forward. If Chambers were telling the truth, this meant that the communists had been able to enlist the active support of men like Alger Hiss in education, background, and intelligence, among the very best the nation could produce. If this were the case, then surely the country should be informed and Congress should determine what legislative action might be taken to deal with the problems. This is the end of the quotation. I would like to add that I consider the investigation being conducted by this committee most crucial to the welfare of the nation. The committee, in short, is investigating allegations that men exercising great financial power, great political power, and great governmental power have impaired, if not destroyed, the integrity of the process by which presidents of the United States are nominated and elected. I don't know anything in which the country could have a greater interest, and anything which requires Congress to determine whether or not such conditions existed and whether legislation is necessary to prevent their recurrence at some future date. Any member of the committee have any statement they'd like to make at this time on this subject or any other? If not, the chair will recognize Senator Montoya.
Thank you, Mr. Chairman. Mr. Moore, you have been testifying for some time before this committee, and I will try to confine my questions to the areas where I believe you might throw some light or clarity. You've had time to reflect over some of the statements that you've made and over the lack of recollection that you have manifested with respect to some of the items contained in the questions asked of you. One of the important questions asked of you deals with the Costa meeting in California on February the 10th and 11th, where for 2 days you met with Mr. Ehrlichman, Mr. Haldeman, and Mr. Dean, trying to develop some kind of strategy with respect to the Watergate affair and perhaps other situations. It has been testified to before this committee by Mr. Dean, and I refer to page 167 of his statement as follows. Mr. Dean, I said as far as I was concerned that they would have to take this up with Mitchell. That's fundraising. In that Mitchell felt it was a matter for the White House at this point. For the White House. At this point, Ehrlichman told Mr. Moore, who was hearing all this for the first time, that he, Moore, should go to Mitchell and simply lay it out that it was Mitchell's responsibility to raise the necessary funds for these men. It had been decided at the outset of the first day of the meetings that Moore would go to New York and report to Mitchell on what had been resolved regarding dealing with the Senate hearings, and now Ehrlichman was telling Moore that an important element of his visit with Mitchell would be for him to get Mitchell to raise the necessary future funds for the 7 Watergate defendants. Then, quoting from Mr. Mitchell's testimony, page 3777 of the transcript, in answer to a question propounded by Mr. Thompson, the minority counsel, he said as follows, and perhaps I should quote the question from the transcript also. Mr. Thompson, let me ask you to recall as specifically as you can exactly what he said to you concerning money. Mr. Mitchell, well, I don't know as I can remember the specific phrase, but there is one thought that sticks in my mind which may or may not be the exact words, but it was something to the effect, you would not be interested in help raise money in connection with these activities, would you? It was more of a question than it was a plea, and my answer to that was negative. Mr. Thompson, what activities? Mr. Mitchell, the activities, the payment for the support and the legal fees of the people that were involved in the Watergate. Mr. Thompson, did he specifically mention support for the people involved in the Watergate? Mr. Mitchell, well, this was the general tenor of the subject matter, yes. Mr. Thompson, did you have any talk about Mr. Mitchell? Or at least I understand when he talked about raising funds that this is what they were talking about. Mr. Thompson, that is the way you received it from your end of the conversation? Mr. Mitchell, yes, sir. Mr. Thompson, did you also discuss the committee to re-elect, how the committee to re-elect was going to function from then on? Mr. Mitchell, yes. Now, in view of the two statements which have been made with great clarity, that your mission in New York was to try to get money for these defendants. In view of the fact that these people have presented their testimony almost exactly, would you want to change yours?
No, sir, but first, that's quite a long question, Senator, and could I have the page reference that you read from so that I could perhaps...
Yes, from Mr. Mitchell, it was page 3777 of the transcript, and the statement by Mr. Dean was on page 167 of his statement as presented to this committee.
We don't have the Mitchell testimony, if it's possible.
I'll be glad to furnish you my copy.
While we're waiting, I would like to say very firmly, as I said yesterday, that if you read the Mitchell testimony carefully, you'll find that he never once said, even though somewhat pressed, that I ever used the words money for these defendants or anything like that. It was clearly a case of his having said that I came in and had a question about, he did use the word, his words were these activities, according to him. You've heard my testimony that I said, John, I don't know what this is quite about, but it seems you've been nominated to be a fundraiser if there may be a need for money coming up. And he said, get lost or something like that. Now, or tell them to get lost.
Well, how could you tell him that you did not know what that was all about when you had spent 2 days at Costa, California with Mr. Ehrlichman, Mr. Haldeman, and Mr. Dean talking about these things?
I did not, as I have testified, know the nature, and I don't know that it has been established to this day, what that purpose of that money was. And all I did is, I think I made it plain, this was one more case of trying to pass the fundraising job to somebody else, and anybody who's been in politics knows that finding your finance chairman is the hardest thing in the world. Getting people to raise money is unpleasant. I knew John Mitchell had no interest in raising money. I knew him that well. I wasn't going to get into a discussion of why I should give him a sales pitch on becoming a fundraiser. I brushed it off in the first, as he testified. He said, it seemed to me, he said it in a sentence or two. It wasn't exactly a question. In other words, I didn't even ask him. What I said was, I think I know the answer to this, but you've been asked. And
well,
that's all. So the testimony, and also in La Costa, you'll find that the testimony that relates to this is really an expression of opinion by Mr. Dean, not an expression of what was said in the meeting. And,
Mr. Moore,
yes.
You knew that there was a balance in the finances in the committee to re-elect the president at that time, did you not?
I think I must have known. I don't know. I didn't have any direct information, but it was a well-known fact, I think.
Well, what did you conceive your mission to be to tell Mr. Mitchell to raise some finances if you did not have the details?
Well, I didn't know, and as I said, I didn't want to get into it. I didn't want to get into this position of persuading John Mitchell to be a fundraiser. I had enough to ask him.
Well,
I want to repeat, Senator, I had a lot of things to ask him to do.
Well, as
and
a lawyer,
this was the least of them, as far as I was concerned.
Well, as a lawyer, Mr. Moore, didn't it arouse your curiosity that you were going to ask a big man like Mr. Mitchell to raise some funds, and you did not tell him what they were for?
It seems to me that, as I best recall, that I was not thinking so much of what they were for as a fact that I wasn't going to make anything of persuading him to do this, A. B, if I were to try to think of what it might have been, and I don't think I did at the time, I don't think I went into it, you had all kinds of lawsuits, you had individual defendants, you had some of the individual defendants who also were criminal defendants, you had plaintiffs' suits by individuals, and there were a lot of funds over there, and I was never part of any aspect of the fundraising business, and I'm never interested in getting into it, and whatever funds were used, I don't know whether committee funds today, to this day, are being used to defray the cost, for instance, of Mr. Stanz's personal lawsuit. I don't know. I didn't ask. I don't know what.
And you didn't discuss these things with Mr. Mitchell?
No, sir.
Well, as a lawyer, Mr. Moore, with a great deal of experience, can you conceive of any person going to see another person and ask that person, please raise some money? I can't tell you what it's for.
Well, I can conceive of it because it's exactly what happened.
Can you conceive that kind of a situation?
I certainly can, because that's what happened, Senator. And the point is, I've been trying to make for 2 days when this comes up, is that this was, on the second day, a 2 or 3 or 4 sentence exchange where one more little buck-passing assignment was given because, to me, that I had no interest in pursuing, and I knew that the recipient of the suggestion would have no interest in it. And I simply tucked it away as one thing I would do in the minimum manner, and that's exactly what I did. And Mr. Mitchell's testimony confirms that that's what I did.
Well, would this be one of the reasons why you can't remember so well, Mr. Moore, that if you would admit that you did ask Mr. Mitchell to try to get this funding for the silencing of the defendants and for the representation of the defendants, that you would be now involved in the cover-up?
No, sir, that is not.
Well, if you had,
first of all,
wouldn't you be involved now?
Well, first of all, you were asking a hypothetical question.
Yes.
And you're asking a hypothetical question that goes to the ultimate stage of the purpose, as being an illegal purpose. If that had been the purpose, and if I had known it to be the purpose, and if I had then done what you just suggested, then I would like to point out I perhaps wouldn't have been so anxious. First of all, it's not so.
Well, then,
and I perhaps wouldn't have been so eager to urge John Dean to go in and tell the president everything that's been happening, including presumably this, which would have involved me had this been the case. And of course, I perhaps might have been here asking immunity, which I've never asked or suggested. So,
well, Mr. Moore, let me ask you the question another way then.
Right.
Then, because of your possible feeling and belief that you might become involved, is this one of the reasons why you hesitated to confront Mr. Mitchell with more specificity with respect to the fundraising?
The reasons, first of all, you've assumed a fear there, which I did not have. Second, the reasons why I confronted Mr. Mitchell with, as I did, was exactly what I stated, and it's exactly the way I put it on these other things that were asked of him that I knew he'd have no interest in doing.
How could Mr. Mitchell, a very intelligent man, as well as Mr. Dean, testify that your mission there was to get money for the defendants?
Well, Mr. Mitchell's testimony was that was the conclusion he drew, that he had this request at least twice before, or 2 or 3 times before. Now, I can see how if the Metropolitan Life Insurance Company has been sending a man in to see me 2 or 3 times, and the third day a guy comes in from the Metropolitan Life Insurance Company, and somebody said to him, and you just said hello and I'm busy, somebody said, what was he there for? Your answer would be, he was there to sell me life insurance. Now, he might have been there representing the Red Cross in this case, trying to get a donation. But the man who has the knowledge that this money has been asked for that purpose would interpret, I might have been an innocent conveyor, and we're also assuming, and I want to make this clear, that there was this arrangement, which was allegedly illegal, and may well have been, I'm not saying, but men are still charged with that, or not even indicted, but it's been suggested, and I'm not assuming anything that is contrary to the presumption of innocence of anybody in that room or anybody at all. So that we're talking about assumptions here. The answer is, in my opinion, and this is what we talked about a number of times, the question, the double hazard in one person saying something, the other person having a different frame of reference and interpreting it differently. Now,
well, I can readily understand, Mr. Moore, that occurring between two persons, but not when the same subject matter has been dealt with by three persons. In this case, Mr. Dean, Mr. Mitchell, and yourself. And they seem to fortify each other's testimony in this regard, and you seem to have a feeling that you did not discuss with specificity the particular mission that you had in mind when you went to visit Mr. Mitchell.
Well, Senator Montoya, going back to you, I didn't quite, in your previous question, where you made certain assumptions. If there were a conspiracy and so forth, it's entirely possible that I had a little bit and being asked to relay this message and been put in that position. But as far as Mr. Mitchell's, you speak of three persons, it's entirely possible that Mr. Mitchell, with his knowledge, and when you note in Mr. Dean's testimony, he said Mr. Moore, and I was summoned the night before from the East, was hearing all this for the first time. And to take the leap, which has not yet been established but assumed at the moment, that I was sitting in the room with two of the men at the highest level of the greatest nation in the world, and that they were talking about an illegal objective on the second day in a two-day meeting with a 3-sentence or 4-sentence conversation, that I was not apparently mentally prepared to take the leap to assume that here on his visit to the President's Western White House with his two closest top-level advisors, that they were talking in this offhand way about something that was illegal. All I knew was that time and again, in my days at the Justice Department, I was asked to intervene to persuade John Mitchell to do something that he didn't want to do, whether it was to make a speech or hold a press conference or that kind of thing. And here I was in that role again. Will you, Dick, go on up? And he didn't relish it. He didn't relish being programmed by he respects them, but he didn't like to be programmed by Ehrlichman and Haldeman. And in that total flavor, in that total context, I just thought to myself, I'm not going to pursue this with John Mitchell. I will mention it, and I know what his answer will be, and that's what it was, and that's what happened.
Well, Mr. Moore, I want you to understand me clearly, that I don't want to attribute to you any dishonest motives whatsoever.
Thank you.
I'm just trying to probe your mind and ask you to tell me whether you were doing this for the reasons that I have ascribed.
No, Senator. I think that, I'd say in closing that whatever, of course, whether conversations had taken place that were background for this, when I was out there, remember, I was a new boy. If there were such a thing as this conspiracy, I hadn't been initiated. I hadn't been given the pin and the instructions. I didn't know anything. I arrived that midnight the night before. I'd met on this subject of this kind for the first time. If there had been any such motive, there were plenty of times and plenty of opportunities for those who did know to have discussed the kind of thing that Mr. Dean has testified to, which, if anything was said like that, it wasn't in my presence that I recall, but if there were things, if it's possible things could have been said that went over my head, but I don't think so. I think that...
Well, you have, or had at that time, great admiration for John Mitchell, and I presume you do still, do you not?
He's my good friend.
And you worked under John Mitchell.
Yes.
And you had great admiration for John Dean, and he had great admiration for you. He so expressed it in this committee. Now, if he said certain things, would you say he said them because he believed them to be true?
Yes.
And would you say the same thing about Mr. Mitchell? If he said certain things, he said them because he believed them to be true?
I worked for a year for him. I never knew him to tell an untruth. Now,
all right.
But what I do want to say, Senator, when you speak of truth, it is entirely possible. In fact, there's an old aphorism, sort of a corollary to Urban's law, that when two people tell exactly the same story, you know that one of them is lying and probably both. That's Judge Stewart of Ohio.
Well,
used to tell young lawyers that. Now,
no, I understand that,
yeah.
Mr. Moore, and I just want to put this thing in proper focus.
Right.
So that the testimony of the two can stand against your version of what took place. Now let us go into another matter. Now you indicated here that you and Mr. Dean had discussed different phases of Watergate prior to the time that Mr. Dean was counseled by you to go in to see the President and tell it like it was. Now, would you relate the dates, more or less, of those conversations with Mr. Dean and what you discussed serially with him with respect to the involvement in Watergate?
Well, I'm not sure I can discuss them in sequence because it didn't flow that way, but I will make an effort.
Well, I believe that you had a meeting on March the 14th with Mr. Dean where he told you about Mr. Hunt demanding a lot of money. Do you recall that?
Sir, I believe that I testified, and I believe that was either late in the day, March 19th, or early in the day, March 20 of 1973. That Howard Hunt had told him of this. He learned of this Howard Hunt blackmail demand.
What day in March?
March 19, late in the day, or early in the day of March 20.
All right. And then did you have another conversation with him on March the 20th, the next day?
Yes.
And was it during this conversation that Mr. Dean told you everything about Watergate? Or what you conceived to be everything?
No, the thing that he had told me that clarified for the first time in my mind that there was a possible criminal or highly improper activity that might affect the White House was on the 19th when he first described what I regarded as a really a criminal act of a blackmail demand by Howard Hunt in return for, or saying, or he reported that he said that unless he received this money by Wednesday, the 21st, Dean's words were he would say things that would be very rough on the White House or very embarrassing to the White House or would involve the White House. I don't know the precise words, but it was the White House. And with the other things, Dean, of course, was starting with his acknowledgement of his presence in those meetings, which he felt, and I felt, and he so described as innocent participation, the meetings with Mr. Mitchell and Mr. Liddy and Mr. Magruder, for example, that the culmination now took this into the White House. The thing had been building up. That's when I said, John, it's that the time has come for the president just doesn't know what's going on. You know things. And I also want to, since it was suggested I...
Was this on the 20th?
The 20th was the day that I made my talk with him when we left the Oval Office. And it was triggered by the final, the advice that he gave me either the night before or possibly that morning. I had kind of a strong recollection it was the day before. Or even, at one point I thought earlier, but not the 20th. But it appears clear now to be the 19th in my mind. That this was the point where this thing got involved, possibly not the president, I didn't know what it would, but the fact that it might involve people in the White House. Hunt knew things, apparently, that for the first time that I could gather went beyond the committee or employees of the committee or outside people, colleagues, advisors to the committee, fundraisers, that kind of thing. That this was a hard comment to the effect that the White House would be involved, and that was the thing that
Then
got me in
it
there.
was on the 21st, the day after, that Mr. Dean went in to see the president
Yes,
and
sir.
told him everything.
He said he told him everything. That's what
Yes.
he told me.
Well, do you believe that he did?
I can't form a belief on that, Senator, because at that point, there were so many new facts have entered into the equation since and become known that,
Well,
first of all, everything's a very big word, and I don't know what he told them, so I can't comment.
Well, didn't the president relate to you that Dean had been in to see him and had told him quite a bit about this affair?
He did when I brought it up.
All right.
And the president didn't, you say quite a bit, the president didn't tell me what Dean had told him either, except to confirm that this blackmail conversation, because I mentioned that to the president, and he sparked to it and said, yes, that's what he told me. And that's in the record. I testified about that.
Well, perhaps the president did not tell you everything, but did he tell you enough to indicate to you that Mr. Dean had actually talked to him about this affair?
Oh, yes, in this sense, that he said Dean did come in. Let me say that, yes, he said Dean did come in. I raised the question. I said, I noticed the date of March 21 in your statement, Mr. President, where you learned of serious new charges. I said, I take it that John Dean told you those. He said, oh, did you know about that or something? And I said, yes, I'd been talking to him the day before. We'd been with you, and I said, did he tell you about that blackmail matter involving Howard Hunt? He said, yes, he did say that exactly, and then the rest is all on the record. And, yes, sir.
Well, I think that's enough background for my next question. You recall the meeting of March 22nd when there was a general discussion around the White House that Mr. Dean should act as liaison with the Watergate committee, or this committee, to be more exact. Do you recall any of the conversations that were taking place at the time?
Senator, at the beginning, did you say a meeting on March 22nd?
Well, there were some discussions on or about March the 22nd,
yes.
Indicating that Mr. Dean should act as liaison between the White House and this committee.
To the best of my recollection, I first heard that here or read about it. I don't think I was in any discussions on the 22nd. The only discussions I remember on the 22nd, and Mr.
But you know that there...
Well, if I could finish, because I think it's important. There were other meetings going on. Mr. Dean testified to. But I believe that was the day when the newswires in the forenoon announced that Mr. Senator Byrd and Mr. Patrick Gray had agreed that Mr. Dean had told a lie in a certain situation. And I think Ron Ziegler called and said, hey, I'm going to get questions on this. Can you come on over and talk about it? Dean came in and out of Ziegler's and my meetings. There were other meetings going on. If there was a meeting about liaison with the Senate, I was not privy to it, and it wasn't in my meetings, and I didn't know about it.
You do know that there is testimony before this committee to that effect?
Yes.
All right.
Yes.
Now, on March the 23rd, Mr. McCord's letter to Judge Sirica was divulged and read. You recall that incident, do you not? And in that letter, Mr. McCord stated that others were involved and that perjury had been committed. Now, did you get involved in any phase of reaction with respect to this letter?
No, sir. No, sir. Not that I recall. Whether Ron was, of course, conversation all over the building the minute that story broke, because it was an important story. But I do not recall getting involved in any phase of any reaction to it.
Now, were you keeping in touch with Mr. Dean all through this time? Were you seeing him every day and conversing with him about different matters?
Yes, yes.
And of course you knew about the President's pronouncements to the press and what Mr. Ziegler would go out and say by way of a press statement in behalf of the President. You were acquainted with all these things, were you not?
Well, when you say acquainted, I did not attend the Ziegler press briefings.
No, but you read about them, didn't you?
Well, yes, I like anybody else. Some I knew about in advance, as we discussed, as to what direction you might want to take. Others I read about the way anybody else would read about.
Now then, on March the 26th, the President, in a press conference through Ziegler, stated that he had complete confidence in Mr. Dean. You recall that, do you not?
I do.
Now, there was a statement in the Washington Post, and I'll read it to you, under date of March 27th. President Nixon denied today that White House counsel John Dean III had any prior knowledge of the Watergate bugging and said he had absolute and total confidence in Dean. The President telephoned Dean this morning from his office in Key Biscayne to discuss with him a Los Angeles Times report that Dean and former presidential assistant Jeb Stuart Magruder had advanced knowledge of the bugging of Democratic headquarters. Following the conversation, White House Press Secretary Donald L. Ziegler flatly denied that Dean had prior knowledge of the bugging. Quote, "The President has complete confidence in Mr. Dean and wanted me again here this morning to publicly express President Nixon's absolute and total confidence in Mr. Dean in this regard," Ziegler said. Do you have any reason to doubt that this statement was made in behalf of the President by Mr. Ziegler?
Well, I have no doubt that the statement was made. You say I speak on behalf of the President. That phone call apparently he was mistaken about, but that was a statement made on behalf of the President, yes, sir.
Well, how could Mr. Ziegler and the President make this statement of full confidence in Mr. Dean when Mr. Dean on March the 21st had gone in to see the President and told him all? Now, how could the President make this public statement?
Well, first of all, I can't speak for the President on this. I don't know. I would, just to clear the record on that.
Well, isn't it incomprehensible that he would?
Well, he did it, and he's an intelligent man, the President is, and whether here in the middle of what was his own investigation, he had his reasons for not revealing publicly suspicions that he held, I don't know. I can only surmise. But I also want to point out that that statement said that Mr. Dean had knowledge of the Watergate break-in and bugging in advance. That has not been proven, and it has been denied. So that just to keep the record straight. Now.
Yes, but the point, the main thrust of this statement was that he had complete confidence in Mr. Dean, and Mr. Dean had told him about everything he had done up to the time that he met with the President on March the 21st.
I can't speak for the President's motives. I don't know. I trust him. I note that in due course, Mr. Dean was asked to resign. Whether this, therefore, was a temporizing part of an investigation where he was not prepared to acknowledge his total disposition until he had further confirmation, I do not know. Also, as I said, I do not know that Mr. Dean told the President everything. But I'm sure the President had a perfectly sound and good reason for, at that point, in responding to that Los Angeles Times story, which was the story that he was responding to, in that way. And
then, on March the 28th, according to an article written by Clark Mullenhoff, he asked Mr. Ziegler if the President still had confidence in Mr. Dean. And in response, Mr. Ziegler told Mr. Mullenhoff that he would check with the President. And he did check, and then came back and told Mr. Mullenhoff that the President had total and complete confidence in Mr. Dean. Now, wouldn't that sound kind of odd, having the President having expressed on 2 occasions complete confidence in Mr. Dean when Mr. Dean had leveled with the President about everything on March 21st?
Well, at first, as I said, I don't know that Mr. Dean told the President everything on March 21st. All I know is that he said he did that. I don't know
Well,
what he
didn't
told
you
him.
indicate that the President had told you that Mr. Dean had told him everything about this thing?
No, indeed, I did not say that, and if I did, I would like to correct that. He did confirm that he had come in, that he had talked to him. The only thing he confirmed to me that Dean told him was the Howard Hunt blackmail incident. That's all the President told me that Dean had told him. And I must say, sir, that the President chose to make that statement through Mr. Ziegler to Mr. Mollenhoff on March 28th, according to that story, and I certainly trust Mr. Mollenhoff's reporting. I don't have the facts, and I don't think anybody in this room does, as to what stage the President's separate investigation was at that time. It may be that at that very time that the President was searching for confirmation of a decision he later made and was not prepared to alert anyone to the fact that Mr. Dean was under a separate investigation. Now, whatever his motives, I think that...
Well, Mr. Moore, let me give you the connection that you're trying to loosen here. Now, on April the 17th, 1973, the President issued a statement. In fact, it was his own. It was the President's remarks. It was part of the President's remarks announcing developments and procedures to be followed in connection with the investigation. And this is what the President said on that day. My second announcement concerns the Watergate case directly. On March 21st, as a result of serious charges which came to my attention, some of which were publicly reported, I began intensive new inquiries into this whole matter. Now there is the President telling the country that he was told on March the 21st of very serious charges, and some of which were publicly reported. Now, would you say that the President had knowledge of these charges at the time that he affirmed his confidence in Mr. Dean, and also the time that he reaffirmed his confidence in Mr. Dean, according to Mr. Mollenhoff, on March the 28th?
When you say these charges, sir, it's hard to answer. What charges are you referring to?
Well, I presume that the President was referring to the very thing that we're talking about.
Serious charges.
Yes.
I don't know that any one of those serious charges was a self-made charge by Mr. Dean against himself. I do not know what those serious charges were. I think that's exactly the point, that the President was at this very time in a process, as he said later, he renewed and intensified his investigation into these matters. I don't know what those charges were, and I don't think anybody in this room knows yet, and I think we'll find out. But at that point, the President was not advertising to anyone who was a suspect, and that's quite proper, who might be involved, and that's quite proper. He said it in general terms, and I don't know what those serious charges were.
Thank you, Mr. Chairman.
Thank you, Mr. Chairman. Mr. Moore, I told you this morning before we began, and I want to repeat it now, that I promised that I won't go back before 1939 in any questions that I ask. Is that agreeable to you, sir?
Well, I appreciate it because my preparation stopped at 1940, so thank you.
I wanted to clarify for the record, first, Mr. Moore, on page 3814, when I was asking you some questions about a meeting concerning IT&T.
Yes. Yeah.
I want to make sure that the record is accurate on that. I asked whether that meeting was held in Mr. Ehrlichman's office. The transcript reads Mr. Rohatton's office. It should read Mr. Ehrlichman's office, and I take it it should be Mr. Ehrlichman's office to the best of your recollection.
My recollection is very clear that you said Mr. Ehrlichman, but I would like to make this comment.
Yes, sir.
In terms of oral communication, how does one leap from the name Ehrlichman to the totally unlikely name of Rohatton? I looked up in our phone books, and that isn't in any phone book in this area. So there's a case of someone who had probably been in that other hearing, a reporter or a typist, who, when you said Ehrlichman, he heard Rohatton and spelled it right too.
He's the next witness, Mr. Moore.
That's quite a example of the twofold hazard of oral communication. But go ahead.
Well, we'll interrogate him next. I wanted also to clarify one other thing. On June the 7th, when we did go over...
What date?
June the 7th, when we met in Mr. Miller's office, we did go over the dates that I referred to in the last inquiry. And I understand also that you had a meeting with Mr. Silberter at the U.S. Attorney's Office sometime in May of 1973. Is that correct?
Mr.
Well,
Lenzer,
can I-
if I may interject at this point of the game, I don't know, I suppose it goes to one's recollection, or either that or your committee reports are inaccurate. That meeting that you have referred to several times when you were interrogating this witness on Thursday of last week, that meeting in my office occurred on the 8th day of June, not the 7th day of June, as you continually referred to it as. And those questions you asked this witness on Thursday about that meeting did not take place until the next day. And I don't know if your committee staff report reflects that day or what, but I know that that meeting took place on the 8th and not the 7th.
Well, the interview, the typed interview indicates it was on June the 7th.
Well, I have in my diary, I have witnesses in my office that meeting occurred in my office on the 8th day of June. Now, if your staff memorandum's incorrect, so be it.
Well, the only question I'm asking now, Mr. Moore, is...
Well, before you do, I have here the 10 references in the record where you gave the wrong date, and I'd like to offer it with the request that it be corrected. And it's 2 on 12. If someone wants them. However, of course, it is my theory that the black, Mr. Lenzer, that failing to remember a bare date without some connection and reference is something that can happen to anybody. And I welcome to the club. It's obviously doesn't affect the substance of what happened at the meeting.
Well, I understand
yes,
that.
and I'm not, trying to press you. It just is a reminder that a date by itself doesn't always connote something to someone.
Well, my point now, Mr. Moore, is we did go over the dates in 1972 that I inquired about, and I just wanted you, and I also understand that you went over those dates at the U.S. Attorney's Office, or some of them, in May of 1973. Is that correct?
Well, now let's see. Let's take them.
Well, did you have an interview? Let me repeat the question, Mr. Moore. Did you have an interview with the U.S. Attorney's Office in May of this year?
Well, just a moment. No.
When was that interview?
April 30th.
And did you go over some of these dates at that time?
Now, will you...
Mr. Chairman, I'd like to address an inquiry to the chair.
Mr. Chairman, Mr. Miller has a question.
Mr. Chairman, just a question that I would raise. Mr. Lenzer has indicated that he's going to commence to interrogate Mr. Moore about interviews that he has had in the United States Attorney's Office. Of course, Mr. Moore has been there in April. He testified or didn't testify. He gave a full and complete interview at the U.S. Attorney's Office. On Wednesday of last week, he spent most of the day with the special prosecutor and members of his office. Now, I'm perfectly willing, if the committee desires, that you interrogate this man concerning what subject matter the U.S. Attorney's Office and the special prosecutor went into with respect to what his knowledge was. I query, Mr. Chairman, at this stage of the game, if this is something that should be considered by the committee. If I were a prosecutor myself, I think I would have some reluctance to have individuals who had been before my office then appear before the committee and be interrogated concerning what they were asked. Now, as I say, it's up to the chair. And
well, I would say that the general rule is that a witness may be asked what he has stated to any other person for the purposes of either corroborating the witness or contradicting the witness.
True.
And I know no exception which would excuse a witness from testifying as to what he told the prosecuting attorney.
As I say, Mr. Chairman.
Or grand jury, for that matter.
Yeah.
I have no...
Mr. Miller, maybe I can cut this short.
And I have no hesitancy in letting him answer
I'm not going
questions, but it was a question of propriety. I just didn't know how...
I'm not going to go into...
Senator Gurney.
May we inquire of counsel what his concern is? I don't think he stated it, and I think the committee perhaps ought to know what the concern is.
The only concern I would have, Senator Gurney, is that it is my understanding, perhaps even knowledge, that there are ongoing investigations into violations of the penal laws of the United States. That the interrogation of witnesses and what they were asked about would permit others who perhaps were under investigation to ascertain the thrust of what the prosecutor was seeking, what areas he was probing into, and generally disclose publicly where his investigation was going. My experience in the past has been the prosecutors are normally reluctant to have this happen.
Well, that's what I thought.
For the simple reason that it permits those who are being investigated and our potential defendants from getting a bird's eye view of what the prosecutor's case is. And that's the only reason I raised the issue. I hasten to add we have no objection if he wants to interrogate these witnesses because we cooperated fully with all of these various agencies.
What counsel is really saying is that it might possibly jeopardize the case of the prosecution. Isn't that it?
That would be my concern if I were the prosecutor. I am not the prosecutor. I am representing Richard Moore.
Yes. I wonder, Mr. Chairman, if Mr. Lenza perhaps could tell the committee the thrust of his questioning, what he has in mind, and then perhaps we'd know whether we needed the evidence or not.
Well, Senator, I would think that the prosecutor has one function under the Constitution, and this committee has another. And each one can exercise its function independently of the other. And I do not believe, I don't know what the prosecutor, what the counsel wants to elicit from the witness, but I do not believe that this committee should abdicate its function for fear that the exercise of its constitutional function might impair the capacity of the prosecutor to perform his constitutional function.
I could not agree.
I think the doctrine of separation of powers clearly requires this view.
I could not agree with the Chairman more. I totally subscribe to that. My only question that I was raising is that if the testimony is not all that pertinent, do we want to jeopardize a prosecution? I think this committee certainly wants all of the culprits brought to justice and doesn't want to interfere with that process. That's the only reason I was raising the question.
The only question I have, Mr. Moore, is on April 30th, did you go over with the U.S. Attorney's Office dates in 1972 of meetings?
Yes. Would you mind when you say that I had quite a few meetings in 72? Would you identify?
Well, generally, did they ask you questions about meetings in 1972? That's all I'm asking.
Yes.
Okay. Now, I also hope that you understood that when we reviewed some of those same meetings here last week, that I was only intending to probe your recollection in view of the fact that you did remember meetings and incidents that did happen and some incidents that didn't happen so clearly. I was trying to exercise a purpose of determining how vivid your recollection was on other meetings. I did not intend in any way to embarrass you in front of the committee.
I didn't feel the least bit embarrassed, Mr. Lenzner, and the only problem I had was that the subject matter appeared to me extraneous, the Dita Beard business and so forth, and I had a hard time connecting your comment about a White House investigation with this episode you spoke of.
Now, let me ask you this, Mr. Moore. In this context, when you prepared your statement last week, did you recollect at that time your conversation with the President on April 19th?
When I prepared my statement?
Yes, sir.
Yes, I made reference to the meeting.
Well, does your statement reflect your conversation with the President concerning Mr. Ehrlichman's involvement with Mr. Ellsberg and also the possible criminal liability of Mr. Haldeman? Does your statement at all mention that?
My statement?
Your statement that you read to this committee last week, sir. Does that reflect your meeting of April 19th that I just described?
I'm not sure. Another thing we have is But what the question is?
Well, the question is, does the statement that you prepared include that meeting on April 19th with the President?
Well, yes.
Well, could you point out the specific reference to it?
As White House Special Counsel Richard Moore takes a moment to check some facts, we'll take a short break. We'd like to remind you that when we take these breaks, you don't miss any of the testimony. We simply stop the videotape and then start it again a couple of minutes from now. Public television's coverage of the Senate hearings will continue after a pause for station identification.
Unabridged coverage of these hearings is provided as a public service by the member stations of PBS, the Public Broadcasting Service. From Washington, NPACT continues its coverage of hearings by the Senate Select Committee on Presidential Campaign Activities. Here again, correspondent Robert McNeil.
We go back to the hearings as Richard Moore is being questioned by Assistant Chief Counsel Terry Lenzner.
At no time during this meeting or during the succeeding meetings...
Can you indicate what page you're on?
Page 13. Or during succeeding meetings on March 15, March 19, and 20, all of which were attended only by the President, Mr. Dean, and myself. Did anyone say anything in my presence which related to or suggested the existence of any cover-up or any knowledge?
As White House Special Counsel Richard Moore takes a moment to check some facts, we'll take a short break. We'd like to remind you that when we take these breaks, you don't miss any of the testimony. We simply stop the videotape and then start it again a couple of minutes from now. Public television's coverage of the Senate hearings will continue after a pause for station identification.
Unabridged coverage of these hearings is provided as a public service by the member stations of PBS, the Public Broadcasting Service. From Washington, NPAC continues its coverage of hearings by the Senate Select Committee on Presidential Campaign Activities. Here again, correspondent Robert McNeil.
We go back to the hearings as Richard Moore is being questioned by Assistant Chief Counsel Terry Lenzner.
At no time during this meeting or during the succeeding meetings...
Can you indicate what page you're on?
Page 13. Or during succeeding meetings on March 15, March 19, and 20, all of which were attended only by the President, Mr. Dean, and myself, did anyone say anything in my presence which related to or suggested the existence of any cover-up or any knowledge or involvement by anyone in the White House then, now, or in the Watergate affair?
No, Mr. Moore, I'm asking you about your meeting on April 19th with the President, where you discussed Ellsberg, Ehrlichman, and
March 19. You're talking about April 19.
Yes, sir.
And the question is it in this statement?
Is it reflected anywhere in your statement? Excuse me. Is it reflected anywhere in your statement? And if it isn't, can you?
No, sir. No,
can
sir.
you explain?
Excuse me.
Why was that
again,
left out?
The two 19ths. Yeah, we're talking about April 19. Right. I was thinking in terms of March 19.
Well, the April 19th statement is not referred to. Can you explain why you did not include that in your opening statement?
Well, a lot of things. Yes, if you look at the portion where I speak of the time frame where I thought I had evidence that would relate to this, what I thought was the basic subject, the meetings which I attended with Mr. Dean and the President. And I took a time frame of February 6 as a start of my acquaintance with the subject, up to and including, I said, March 21, the date the President first learned of the possibilities or facts that he referred to in his latest statement. I had, as you know, a lot of things were not included here. I indicated I'd be glad to go into any and all other subjects, but this was what I thought was the heart of what I could provide, and so stated.
Now,
yes.
After you learned in March of the meetings in Mr. Mitchell's office with Liddy, Magruder, and Dean, did you ever see Mr. Mitchell again to talk with him after that?
Oh, I'm sure I did.
On a number of occasions?
No, once or twice. I saw him once when he was in the White House. He was down there on a visit. I've seen very little of him.
Well, did you ask him on that occasion or any occasion about the meetings that he had in his office with Mr. Liddy, Mr. Dean, and Mr. Magruder that Mr. Dean had described to you?
No, sir.
I believe you saw him on March 28, 1973, at the White House with Mr. Haldeman. Did you have any discussion on that date?
Well, you say I believe I saw him.
Well, I'm reading from a notation of Mr. Haldeman's diary that indicates you, Mr. Haldeman, and Mr. Mitchell met on that date.
What was the date? The date is March 28,
Yes, sir.
1973. Well, if you'll give me a moment to... I just want to see if I have any notes.
Take your time, Mr. Moore. While you're doing that, I'm told by my associate up here that Mr. Miller spoke about our meeting on Thursday, June 8th. Mr. Lackridge tells me that Thursday of that week was June 7th. But go ahead and pursue your...
No, he didn't say that. You didn't hear him correctly.
Friday, the 8th of June was the date of the meeting, Mr. Lenzer. I have competent evidence available if necessary.
Go right ahead, Mr. Can you describe, Mr. Moore, by the way, what you're looking at to refresh your recollection?
Yes, sir. It's some notes I made just for this purpose after my little discussion of dates with you. You were telling me that Mr. Haldeman's diary shows that I was present in a meeting on March 28th.
That's correct.
At which Mr. Mitchell was present. Can you tell me if anybody else was present?
The diary only indicates that Mr. Haldeman joined the meeting at approximately 9 o'clock. I'd be glad to...
Do you know where? I don't have that.
It looks like Mr. Haldeman's office in the White House. Because it would, I think this diary would not reflect this entry unless it was his secretary at his office.
What day of the week are we on?
This is Wednesday. He said after his last week.
Could you tell me whether that is a diary of a meeting that took place or a meeting that was scheduled?
Well, it indicates, I'd be glad to show you the diary.
At the moment, I have no recollection of such a meeting.
Indicates Haldeman returned, joined Mitchell and Moore. It's on the right-hand side, Mr. Moore, of the diary entry.
8:15. That's an EOB.
time appears to be 12:45. Is that the way you made it?
Excuse me, sir?
The time of day?
About 8:45, I think it says, yes. Well, I don't want to belabor...
No, I don't usually get in that early. I have no recollection of the meeting. I don't really think I was at that meeting. Now, I admit the diary shows that. I don't know whether it could have been Powell Moore, my good friend from Milledgeville, Georgia, whose name has been confused with mine a couple of times, and I might say, for the benefit of anybody I should, that I'm Richard and he's Powell. And but
well, above
I
the
don't
entry,
recall being at that meeting, but I will.
above the entry at 8:45, it says Dick Moore.
Yes, you're
but
right.
I don't want to belabor this.
No,
the
that's
only
right.
point,
I see that now.
The only question I'm asking is, did
Yes.
you ever, when you did see Mr. Mitchell, ask him about the meetings that Mr. Dean had told you about in his office?
No, I never did.
Now, you testified also, sir, that on or about March 19th, Mr. Dean told you that Hunt was demanding, I think you said, over $100,000, that he wanted to...
What I said was that he mentioned a large amount, and I didn't remember what it was, but I've since read that it was over 100,000. Yeah.
Well, whatever it was, and he wanted it by Wednesday, or he was going to embarrass the White House. Now, did you ask Mr. Dean for any specifics as to how he could embarrass the White House?
No.
When you characterized it as blackmail, what was your basis for so characterizing it?
He was said some characterization. This things have gotten to terrible. I've just learned that Howard Hunt is demanding X $1,000, and he wants it before he's deposited or before he's sentenced. In fact, he wants it by Wednesday, and if he doesn't get it, he's going to raise hell with the White House, or he's going to say things that'll raise hell with the White House, or words to that effect. I don't remember the precise words.
Well, now, after you realized that this was a pretty serious thing going on, did you take any action? Did you contact any law enforcement agencies to advise them that a crime of some proportion was about to be committed the next day or the day after?
No. I was talking to the counsel of the chief magistrate. I thought that the main thing was to... No, I didn't.
Now, if you had talked to the FBI or the U.S. Attorney's Office, they would have been able to provide surveillance and perhaps prevent a serious crime from being completed. Is that not correct?
I don't know what they would have done. They might have said, what evidence do you have? I don't know what they would have done. What I had was someone had told... Dean told me that someone had told him that Howard Hunt had said this, and maybe the FBI would have acted. I don't know. The time frame is pretty fast anyway. We get there the next day, or within 36 hours.
That's my point.
If it was Friday, right.
Well, when you talked to the U.S. Attorney's Office on April the 30th, did you relate that conversation that you had with Mr. Dean concerning the blackmail?
I'm pretty certain I did. And I also, at that time, had a notion it was could have been earlier. But as I think I said, I knew it was before Wednesday. For some reason, that timing stuck in my mind, and I did tell him about it.
Now, when you met with the President and Mr. Dean on March the 30th, did you have a discussion which concerned Mr. Mitchell?
Here we go again. March the 30th. I did not have a meeting with the President.
I'm sorry. I apologize.
It's tough.
I apologize. I meant March the 20th.
March the 20th. And the question was, did
you have a discussion with Mr. Mitchell, about Mr. Mitchell on that date with Mr. Dean and the President?
No, sir.
All right. Now, we furnished you, Mr. Moore, with a... let me ask this. Did you and the President agree on that date that the investigation should be made public immediately after the sentencing of the defendants?
Did the President and I agree that the report should be...
that the investigation that was ongoing at that time should be made public and that a statement should be released after the sentencing of the defendants.
On March 20?
Yes, sir.
Now, you referred to an investigation that was ongoing at that time. Which investigation are you referring to?
Well, I take it that means whatever facts that the White House had obtained.
You mean we're still under investigation, or you said an investigation going on at that time? Now, I'm not sure what that refers to.
Well, I'm not sure either, sir, but you were at that meeting, and I'm asking, was there a discussion about an investigation that was going on and that the results of that investigation should be made public?
There was no discussion of any investigation that was going on. There was an expression by the President that he was in favor of getting the story out as soon as we could. Right.
And there was no discussion of Mr. Mitchell or the Vesco case, to your recollection?
No, sir.
Now, we furnished you, Mr. Moore, with a copy of the White House reconstruction of a variety of meetings between the President and Mr. Dean. And I want to direct your attention at this point to the date in that reconstruction that was furnished us by the White House to March 20, 1973.
Could I request an additional copy? I seem to mislaid mine.
I think we gave that to you all last week. I don't know if we have. Well, let me read you the entry, and then I'll be glad to.
If I can work from the who got the document? You check.
Yeah.
Well, we do have a copy. We'll furnish that to you right now. As I said, Mr. Moore, just so your understanding is accurate, this is a document, information that was furnished us by the White House, which is reconstruction by them of the meeting on March 20th and other meetings, but this meeting on March 20th. And I quote.
Was this furnished by the White House?
This is furnished by the White House, yes, Mr. Miller. I want to quote now, on March 20th, the entry. Dean discussed Mitchell's problems with the grand jury, Vesco, and the Gurney press conference. Do you see where that starts?
I saw that at the time.
The President and Moore agreed that the whole investigation should be made public and that a statement should be released immediately after the sentencing of the defendants. Now, Mr. Moore, is that an inaccurate reconstruction by the White House of that meeting?
I believe it is, because I don't believe those things were said in my presence, but I'm just, I don't know who in the White House prepared this. Do you know anything of its,
I believe it was Mr. Buzzhart, I assume, conferring with people who were at that meeting. Were you, I would hope that they talked to you about that before they reconstructed it.
Well, I don't know why they would, but they did not.
Okay.
Mr. Lenzer, I've been informed, and I don't know if it's fact or not, that this document was not in fact prepared by the White House. Now, that is hearsay information on my part.
I think Mr. Thompson received this information from Mr. Buzzhart. Maybe he can clarify this.
Excuse me just a minute. If I could shed a little light on this. We've discussed this a time or two before.
I might suggest that the President indicated during the week of the cessation of the hearings of the committee while the Russians were visiting America that somebody leaked this to the press. That is Mr. Buzzard's substance, Mr. Buzzard's statement. It has been stated in the press that, as I understand it, that this statement was subsequently repudiated by the
May I address myself to that just a minute? It was stated, I think, a time or two before. The substance of this information was communicated to me orally over the telephone by Mr. Buzzard. I don't recall the exact date. Pursuant to the committee's inquiry as to what did in fact occur on those dates. This information was submitted to me orally. I took longhand notes. That same day, I dictated from those notes the summary which we've been referred to. I gave a copy to Mr. Dash, and it was made available to members of the committee. Now, the preciseness of those conversations and so forth, perhaps there can be disputed to a certain extent, but I believe it has been verified that what is in that document, the substance of what's in that document is accurate. Obviously, there is room for some slip-up, I imagine, in the nature of the way the thing was transmitted. And we did not discuss at that time how it would be used or whether or not it would be made a part of the record or whether or not it would be the official White House position. But that is how it transpired, and that resulted in the document which we referred to.
And Mr. Thompson, I could add this, that on receipt of it, I did make contact with Mr. Garment and Mr. Buzzard so that if we were going to use it, we wanted to make sure that they saw your reconstruction on your notes, and they did come down in my office and read your notes and stated that although it was not a verbatim statement of the telephone call, it was generally accurate.
Generally accurate?
They found nothing on these. They said it was not a verbatim statement of word for word, but that it was an accurate statement.
An accurate as distinguished from generally accurate?
It was accurate, yes.
Well, you might want to take this up, Mr. Moore, when you return to the White House today, but
if I could get the thrust of if you had questions about...
Well, the question was, does that entry of March 20th coincide with your recollection of what was discussed on that date? You've already indicated that you couldn't recall a discussion about Mitchell, Vesco, and the grand jury, and you've also indicated that there was no discussion about you and the President agreeing on making this investigation public. Now, are you saying that this entry is not an accurate reflection of that meeting?
Well, it is. Some of it is reasonably accurate. Some I can't recall. For instance, it does refer to that suggestion about challenging the committee to its own investigation, which I stated. I think I stated in various languages that in various words at various times that the President indicated his desire to get the whole statement out about the whole thing, and that we agreed. I think probably, I don't know whether Mr. Dean raised a question about waiting till after the sentencing, but there was I recall, no firm decision on that. Mitchell's problems with the grand jury. Grand jury in Vesco. I don't think there was any discussion of that. I don't know about whether Mr. Dean reported something that we'd gone up there or something. I don't know. I don't recall that at that meeting. And I wondered if the log showed whether Mr. Dean had another meeting that day with the President. I've forgotten. Perhaps you have that there. And I'm not sure whether we got there at the same time.
Well, let me ask you this, Mr. Moore. You did testify that when you left the Oval Office on March 20th, you concluded that the President could not be aware of the things that Mr. Dean was worried about. Now, did that include, for example, the threat by Mr. Hunt to blackmail the White House?
Yes.
Did it also include the earlier activities of Mr. Hunt and Mr. Liddy that Mr. Dean had also indicated could be embarrassing to the White House?
I had no laundry list in my mind. I had except the Howard Hunt matter, but the general feeling that the man in that Oval Office who was telling us so strongly that everything that anybody knew should be disclosed as soon as possible, and that we should get the story out, and he had said it before, that this was utterly incompatible with his having knowledge, prior knowledge of any of these things. And that's what I say. When I left, I said, John, I pointed into that room, I said, that President doesn't know the kind of things that you're talking about and worrying about. Have you told him and so forth? You've heard the story.
Yes, sir.
And it was a sense that this man, with this frame of mind and this desire to tell the whole story or whatever it was, didn't know the whole story. Didn't know anything about what was going on. So that was my conviction.
And I take it including the things that Dean was telling you about Hunt and Liddy's activities that you, I think, once said to us could blow the roof
the
off.
whole field of suspicion and knowledge and problems that seem to be lying there.
Mr. Moore, do you agree now that your understanding of the President's information and knowledge was basically incorrect? That he did, in fact, have information at that meeting, by that meeting on March 20th, concerning Mr. Strawn and also possible involvement in Watergate, and also concerning the Ellsberg break-in involving Hunt, Liddy.
I have no reason you've heard my statement on that, of course, that he did not, that was my judgment that he did not. I know of nothing to change that.
All right, sir. Now, could you again, referring back to the White House reconstruction of the meetings with Mr. Dean, if you'll look at the item on March 13th.
I know.
It says, Dean said there was nothing specific on Colson, that he didn't know about Mitchell, but that Strawn could be involved. And then on March 17th, at the bottom of the paragraph, it said, and this is an admission by the White House of the discussions that took place on that date, Dean told the President of the Ellsberg break-in, but that it had nothing to do with the Watergate. Now, you weren't present at those meetings, but does that information, as admitted by the White House, now indicate that, in fact, your perception was wrong and that Mr. Nixon, the President, did know about both Strawn's possible involvement in the Ellsberg break-in?
Well, it seems to me that the answer to that question can only be given to you by someone who was at the meeting. And when you speak of the White House report, and we use the word White House, which is a building, rather loosely, anything done in the White House is done by a person. And when you speak of this as a White House report, Mr. Thompson very candidly and properly has said this is his summary of a telephone conversation. So I want to get those. Now, all I know is what I saw and heard. And I do not know what the nature of these conversations were, or what the frame of reference was about. There are adjectives and there are words in here about involvement. I have no knowledge of what was said. I wasn't there. This is Mr. Bazard obviously wasn't there if he made the phone call. I don't know what the source of the statements, the recollections are. So I would say that this again could well be Irvin's law to the third power over the telephone. We summarize. So I can't speak or vouch for anything in this, which has been variously described as a White House document, and then turns out, I remember asking about whether it was in the New York Times. It was, and it was a report of a telephone conversation, and I cannot account for that. It doesn't change my opinion one bit. And I think that if you want to get at that, you should ask someone who was at the meeting.
Well, we have had Mr. Dean up here,
all right,
Mr. Moore. We have his version. Do you think, would you recommend that we also get anybody else that was at that meeting up here as a witness?
Well, there are certain constitutional considerations here that even as important as these hearings are, the Constitution may be more important. And, but no, let me just reread this. The President, what I get out of it mostly is Strawn could be involved. What else have we got?
You weren't President.
No. A statement under these circumstances, fourth hand, I guess, or whatever, that Strawn could be involved, I don't take as knowledge that might have come through to the President in those terms, if indeed it was said. Well, so I can't comment. We've had so much of this conversation problem, and we've seen it illustrated quite a bit today, back and forth. I can't comment on those.
Well, of course, you were not at those meetings, but and this is the White House version of those meetings, but so you can't testify as to whether the President did or did not know about that information, how detailed it was, what he did after those meetings to obtain additional information. Isn't that correct?
That's correct.
Do you know, by the way, whether after he learned of the Ellsberg break-in, whether he called in Mr. Ehrlichman, Mr. Krogh, Mr. Young, and interrogated them as to their possible involvement in the Ellsberg break-in?
No, I do not.
Now, you also testified that on about April 13th or April 14th, you learned then of Mr. Ehrlichman's relationship to Mr. Ellsberg. Now, again, I don't want to quarrel with your recollection, Mr. Moore, but isn't it true that you in fact learned of that information sometime in early March?
What's the transcript reference on that testimony?
I think it's, I'll get that for you in a second. It's the last question on the morning of the afternoon of July 13th. I'm sorry. It's on page 3845.
Now, what was your, if I could have the question?
Well, the question is, did you in fact learn in early March about the Ellsberg break-in from Mr. Dean?
Well, when you say learn about the Ellsberg break-in, that had been in the newspapers long ago, hadn't it? So when you say learn about it, what do you mean?
Well, it wasn't in the newspapers in March of this year. It was in the newspapers after it was disclosed out at the trial in,
No,
I
I meant
believe,
the
April
fact that there was a
25th.
break-in of the Ellsberg psychiatrist's office. Wasn't that news?
I don't think so, Mr. Moore. I think that was first disclosed on about April 25th when Judge Byrne...
I mean to the public. Did the doctor not disclose it? I don't remember whether I read it or not before, but I thought I did.
All right, sir. Well, let me ask...
Yeah. Oh.
In any event, let me ask you this. You did go see the President on April 19th, and you had a discussion about what Dean had told you concerning Mr. Ehrlichman and Mr. Ellsberg. And
go ahead, yes.
Is that correct?
Well,
At that time, did the President tell you that Mr. Dean had advised him of that incident on March 17th?
No, he did not.
And similarly, in answer to, I think, Senator Gurney's question, you've also testified that Mr. Dean didn't tell you what he had told the President. Is that correct?
He testified that he let it all out and told him everything.
But he didn't tell you the specifics of whether he talked about $1 million of the Ellsberg break-in or anything else?
That's right.
Now, are you also aware that the day before your meeting with the President on April 19th, that is on the day I'm talking about now is April 18th, the President ordered Mr. Peterson of the Department of Justice to confine his investigation to the Watergate case and not get into national security matters, including the Ellsberg case?
I'm not aware of that.
Well, you have read the President's statement of May 22nd, have you not, sir?
All right.
Well, let me read.
Sorry, I thought you meant of my own knowledge. Right. I'll be glad to.
Well, let me read you the pertinent part. It says, therefore, I instructed Mr. Haldeman. Excuse me, pertinent part is down here. For example, on April 18th, 1973, when I learned that Mr. Hunt, a former member of the Special Investigations Unit at the White House, was to be questioned by the U.S. Attorney, I directed Assistant Attorney General Peterson to pursue every issue involving Watergate, but to confine his investigation to Watergate and related matters, and to stay out of national security matters.
I'd like to find the reference so I can. It's as you recall, a 4,000-word statement, Mr. Lensner, and I'm just looking for the reference. Is it the early part, or?
Well, it's under the...
Does it have a caption, or it's caption?
The caption is forbidden area.
That is a newspaper reproduction?
Well, I guess it is, sir. Yes, I don't know.
The caption forbidden area doesn't appear in the official text. I guess that's it.
Well, let me...
No, but I'll find it. I just don't like to take a paragraph without knowing what the context was. Is it in the...
Let me pass this up to you.
Just give me a moment and I'll find it. Well, maybe if yes. I now have it, Mr. Lensner.
Now, that special investigation unit was with reference to the plumber's activities. Is that not correct?
It refers to national security matters.
And it refers to the special investigation unit, does it not?
I directed Assistant Attorney General Peterson to pursue every issue involving Watergate, but to confine his investigation to Watergate and related matters, and to stay out of national security matters. If there's a reference to the plumbers, maybe you can point it out and I will...
Well, the sentence above it, where it refers to Mr. Hunt, the sentence above that, where it refers to Mr. Hunt, is a former member of the Special Investigations Unit. That was the plumber's unit, was it not?
Special investigations we had in it. Call it, I'll go along. I guess so. Go ahead.
Well, the question is, really, Mr. Moore, wasn't that an indication that there was intent to keep the lid on the Ellsberg break-in story?
I can't testify to that. If you read it, you won't find that here. Now, I'm not going to try to read the President's mind. I think that he's expressed throughout this his interest in protecting the national security, and but when you use words like keep the lid on and that kind of thing, that's your characterization of the President's statement, and you're free to make it, but I don't join in any interpretation.
Well, can you explain then, Mr. Moore, why the President, who received information on March 13th concerning Mr. Strawn, on March 17th concerning the Ellsberg break-in, and on March 21st from Mr. Dean on the other matters, failed to communicate any of this information to the Department of Justice, the FBI, or any law enforcement agency? Can you explain why that information was not transmitted to investigative unit outside the White House?
Well, now, Mr. Wednesday, you've got three things, I think, in there, and maybe the reporter could read them back and I can take them one by one, because I can't give you a collective answer. Could you, sir,
Will it communicate any of this information to the Department of Justice?
No, I'm talking about the three. No, if you could read the question from the beginning, because it has three items in it, and I think each one may require.
Well, let me try.
Well, I think I'd rather get the answer, if you don't mind.
Go ahead.
The question.
Can you explain then, Mr. Moore, why the President received information on March 13th concerning Mr. Strawn?
Wait a minute. Now, I don't know what information. No, I wanted to ask you about.
But I know I only got two hands.
All right.
I got
Oh, quite right, sir. I thought you could do it one-handed.
No, I can't. All right. Want to ask you?
Mr. Moore, would you go ahead? Would you like to comment on that?
I don't know what information he received from Mr. Strawn.
Well,
about Mr. Strawn.
Looking at the White House law reconstruction, and you know that he received information from Mr. Dean on March 21st. Can you explain to this committee why that information was not transmitted to a law enforcement agency before Mr. Dean in April himself transmitted the same information to the U.S. Attorney's Office.
Well, that's really why I wanted the question read back, because I don't know of anything in your question that indicated the President received any knowledge of any illegal activity.
Well, you've already read the White House reconstructed version of the meetings between Mr. Dean and the President, which indicates information allegedly involving criminal acts. Now, what I'm asking is, if the President had that information, and he admitted on May 22nd in his statement that he did receive such information, why then did he not transmit that information to a law enforcement agency so it could be investigated?
Well, Mr. Lansner, we're talking about what you keep calling this White House report or so forth. We're talking about a recapitulation of what someone told Mr. Buzzard, who told Mr. Dash what was said at the meeting. And what it says is, about Mr. Strachan, was that he might be involved. Involved in what? In what way? I just don't know, and I don't think any of us know. And certainly there's nothing here that I can find on which to predicate a question to the television audience that the President knew of criminal activity that he didn't report. I don't find it here.
Well, assuming that this is an accurate reconstruction, and it refers to the Ellsberg break-in on March 17th, and it refers to...
Where is the reference to the break-in?
March 17th.
Well, where is that reference?
On page 3 of the White House version of the meeting. This is my last question, Mr. Moore, if we can finish it.
All right.
And the President did indicate that he was aware, when he talked to you later, about the blackmail threat.
Yes, sir.
And the White House version again indicates that on March 21st, the President received information that Magruder probably knew, Mitchell possibly knew, that Strawn probably knew, and that Haldeman had possibly seen the fruits of the wiretaps through Strawn, that Ehrlichman was vulnerable because of his approval of Kalmbach's fundraising efforts. Can you explain now why that information, as admitted by the White House, was not transmitted to a law enforcement agency for further investigation until April, after Mr. Dean had already talked to the U.S. Attorney's Office? Can you explain that at all?
I have no explanation of my own knowledge.
Now, how can this committee find out the answer to that question, Mr. Moore?
Well, I've not... I think the first thing is, I'm sure as you can find out what the facts were, the President, as I think I said yesterday, I didn't think the President would, as a lawyer, or could, as the chief executive, immediately take public action, for example, on the basis of whatever it was that one man told him in that meeting, and that he had to test and find out the truth and facts for himself, in my opinion. I was not there. I did not talk to him, as you know, between March 21 and sometime in April. He did make these moves. You do have the April 17th statement where suddenly the entire approach changed, executive privilege, cooperation. We were all free to come up here. No one would be covered up. No one would be granted immunity, no matter how high in the administration. But I don't think that after a year of rumor and hints and so forth, that the President could act on a presumable factual basis, because one person had told him these things. It started him, it triggered him, it caused him to renew and intensify, and today, as you know, total changes have been made already in the structure of the White House and the top personnel, and I think that he moved pretty judiciously, and he moved pretty effectively, and I think as Chief Magistrate, he immediately was working with Mr. Kleindienst, the Attorney General, and Mr. Peterson, the criminal head, so forth. I think the results speak for themselves, and I think there's where it stands.
You have no explanation then, though, when the Mr. Peterson and Mr. Kleining went to talk with the President in April, why he had not prior to that time furnished them with the information he had concerning these allegations.
Well, I don't know whether he did or not, and I don't know what information he had, and I don't know at what point he was ready to accept this to the point of putting it into the hands of the criminal division. And I must say, and one thing you must remember, that when things start to move into the departments, they often end up in the newspapers, and I think this was too important. This is my opinion. I shouldn't be sermonizing, should I, Mr. Attorney? But that he wanted to have a pretty good idea himself of what was going on before he went outside the walls of the White House. Although I don't know, maybe he was talking to them. So, point is, I've given you the narrative and the sequence and the results. And things are moving forward. They're moving forward on all levels actively. We have the special prosecutor. We have these hearings. We have the complete release of attorney-client privilege, executive privilege. We have the open book of being offered by the President of the United States. And I think that he reached that decision and that conclusion in a judicious, sensible way, a lawyer-like way, and the way of a responsible chief executive.
I have no more questions. Thank you, Mr. Chairman.
I have no questions.
Owing to the necessity of the chairman and vice chairman meeting with certain parties at this time, the committee will stand in recess till 2 o'clock. First, I want to thank you, Mr. Moore, for your cooperation with the committee.
Am I excused now, sir?
Yes.
Thank you.
So Richard Moore has ended his testimony the way he began it, by maintaining he believed the President knew nothing of the Watergate cover-up. In a moment, we'll hear the most startling testimony of the day, possibly the most startling testimony of the hearings, from former White House aide Alexander Butterfield. Public television's coverage of the Senate Watergate hearings will resume after this pause for station identification.
Unabridged coverage of these hearings is provided as a public service by the member stations of PBS, the Public Broadcasting Service. From Washington, NPAC continues its coverage of hearings by the Senate Select Committee on Presidential Campaign Activities. Here again, correspondent Jim Lehrer.
As we go back to the hearings, the committee is about to get some confirmation of John Dean's suspicion that his talks with the president were recorded. The surprise witness is Alexander Butterfield.
Yes, it is. Subcommittee will come to order. Mr. Butterfield, will you stand and raise your right hand? You swear the evidence that you shall give the Senate Select Committee on Presidential Campaign Activities shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do, Mr. Chairman.
Be seated, and suppose you, for the record, that you state your name and present occupation and address.
My name is Alexander Porter Butterfield.
Yes, yeah.
I am the administrator of the Federal Aviation Administration. My home address is 7416 Admiral Drive, Alexandria, Virginia.
Thank you.
Mr. Chairman, at a staff interview with Mr. Butterfield on Friday, some very significant information was elicited. It was attended by majority members of the staff and minority members. The information was elicited by a minority staff member, and therefore I'd like to change the usual routine of questioning and ask minority counsel to begin the questioning, Mr. Butterfield.
Thank you, Mr. Dash. Mr. Butterfield, I understand you previously were employed by the White House. Is that correct?
That's correct.
During what period of time were you employed by the White House?
I would like to preface my remarks, if I may, Mr. Thompson.
I'm sorry, I believe you do have a... Go right ahead.
Although I do not have a statement as such, I would simply like to remind the committee membership that whereas I appear voluntarily this afternoon, I appear with only some 3 hours' notice and without time to arrange for permanent counsel or for assistance by a temporary counsel. That's all I have to say, Mr. Thompson.
All right. During what period of time were you employed at the White House, Mr. Butterfield?
I was at the White House as a deputy assistant to the president from the first day of the Nixon administration, January 21, 1969, until noon of March 14, 1973.
And what were your duties at the White House?
My duties were many and varied, as a matter of fact, Mr. Thompson. I'll try to state them briefly. I was in charge of administration, that is to say that the staff secretary, who is the day-to-day administrator at the White House, reported directly to me, and of course I reported to Mr. Haldeman, as did everyone. In addition to administration, I was responsible for the management and ultimate supervision of the Office of Presidential Papers and the Office of Special Files. Both of those offices pertain to the collection of documents which will eventually go to the Nixon Library. Thirdly, I was in charge of security at the White House insofar as liaison with the Secret Service and the Executive Protective Service is concerned, and insofar as FBI background investigations for prospective presidential appointees is concerned. A fourth duty was that I was the Secretary to the Cabinet. I had that duty not from January 21st, 1969, but from November, I believe November 4th, 1969, through until the day I departed, March 14th of this year. I was additionally the liaison between the President and the Office of the President and all of the various support units. By that I mean the Office of the Military Assistant to the President, the Office of White House Visitors, again the Secret Service, the Executive Protective Service, the Residence staff, Mrs. Nixon's staff. I served as sort of the conduit between all of those elements and the Office of the President. Finally, I was in charge of the smooth running of the President's official day, both in Washington, D.C. and at the Western White House in San Clemente. I had nothing to do with the smooth running of his day in Florida or at Camp David, but I was responsible for the smooth implementation of the official events on his calendar in Washington and at the Western White House. That pretty well sums it up, sir.
So you were employed on January 21st, 1969, and continue to be employed until March 14 of this year. Is that correct?
That's correct.
Mr. Butterfield, are you aware of the installation of any listening devices in the Oval Office of the President?
I was aware of listening devices. Yes, sir.
When were those devices placed in the Oval Office?
Approximately the summer of 1970. I cannot begin to recall the precise date. My guess, Mr. Thompson, is that the installation was made between, and this is a very rough guess, April or May of 1970 and perhaps the end of the summer or early fall 1970.
Are you aware of any devices that were installed in the Executive Office Building office of the President?
Yes, sir, at that time.
Were they installed at the same time?
They were installed at the same time.
Could you tell us a little bit about how those devices worked, how they were activated, for example?
I don't have the technical knowledge, but I will tell you what I know about how those devices were triggered. They were installed, of course, for historical purposes, to record the President's business, and they were installed in his two offices, the Oval Office and the EOB office. Within the West Wing of the White House, there are several, at least three, perhaps four, but three that I know of, boxes called presidential locator boxes. These are square boxes approximately 10 by 10 inches, and on them are several locations, about 7 locations, which would tell where the President might be at any time. Locations such as the residence, that's one of them. South Grounds is another. Oval Office is another. EOB office is still another. West Wing, meaning West Wing of the White House, is another, and out, I think, is the last one. When the President moves, East Wing is still another, and I think that covers all of the locations indicated on the box. When the President moves from his Oval Office, for instance, to his Executive Office, Building Office, and he departs the West Wing and crosses the street, it is my understanding that the Secret Service agents, members of the Presidential Protective Division, who cover him, and there are 4 to 5 to 6 of them who would move with him across the street, one of them calls a central location, which may be the police switchboard under the East Wing, or it may be a Secret Service command post. I don't really know. If it's a Secret Service command post, it's in the Executive Office building, and says that the President is leaving the West Wing, going to the EOB office. They would know this. And the little light moves from Oval Office to EOB office. It doesn't actually move to EOB office until the President enters the EOB office. And as that light moves, there's a tiny audio signal, so that if one is preoccupied, such as I might be, I realize that the locator box is indicating a change in the President's location, and that kind of information was important to me. My office was located immediately adjacent to the President's Oval Office on the west side. My duties involved going in and out frequently and working directly with the President. Mr. Steve Bull, who at that time worked on the other side of the President, on the east side of the Oval Office, had one of these locator boxes, and Mr. Haldeman had a third. I believe there was a fourth in Mr. Chapin's office. In fact, I'm sure there was a fourth in Mr. Chapin's office. We were probably the four who would be most concerned, or at least most immediately concerned, with the President's whereabouts or the fact that he was changing locations. In that, the Oval Office and the Executive Office Building office were indicated on this locator box. The installation was installed in such a way that when the light was on Oval Office, the taping device was at least triggered. It was not operating, but it was triggered. It was spring-loaded, if you will. And then it was voice-actuated. So when the light was on Oval Office, in the Oval Office and in the Oval Office only, the taping device was spring-loaded to a voice-actuating situation. When the President went to the EOB office and the light was on EOB office, there was the same arrangement. For those two offices, the arrangement was the same, and the taping picked up all conversation or all noise in those two offices when the light was at those positions.
We've discussed the Oval Office and the EOB office. What about the Cabinet room? Was there a taping device in the Cabinet room?
Yes, sir, there was.
Was it activated in the same way?
No, sir, it wasn't, and my guess is, and it's only my guess, is that because there was no Cabinet room location, per se, on the locator box, there was only a West Wing indication. When the light was on West Wing, that meant the President was in one of two places, the Cabinet room or the barber shop. When he went into the Cabinet room, the light went to West Wing. But he could have been someplace else in the West Wing, and so to ensure the recording of business conversations in the Cabinet room, a manual installation was made.
I don't want to hurry you, Mr. Butterfield, but I understand there's a vote in about 12 minutes, so if we could go through it rather rapidly the first time, we might come back and pick up some of the loose ends. I understand the recording device in the Cabinet room was manually operated then. Is that correct?
That's correct.
Were there buttons on the desk in the Cabinet room there that activated that device?
There were two buttons.
Was there also, pardon me, was there also an activating device on your telephone?
Yes, sir. There was an off-on button, or one that said Haldeman, one that said Butterfield. That was on and off, respectively, and one on my telephone.
How was the device usually activated? By the buttons or by your telephone activator?
To my knowledge, the President did never pay any attention to the buttons at the Cabinet table. It was activated by the button on my telephone by me.
All right. As far as the Oval Office and the EOB office is concerned, would it be your opinion?
be the police switchboard under the east wing, or it may be a Secret Service command post. I don't really know. If it's a Secret Service command post, it's in the Executive Office Building. And says that the President is leaving the West Wing, going to the EOB office. They would know this. And the little light moves from Oval Office to EOB office. It doesn't actually move to EOB office until the President enters the EOB office. And as that light moves, there's a tiny audio signal, so that if one is preoccupied, such as I might be, I realize that the locator box is indicating a change in the President's location, and that kind of information was important to me. My office was located immediately adjacent to the President's Oval Office on the west side. My duties involved going in and out frequently and working directly with the President. Mr. Steve Bull, who at that time worked on the other side of the President, on the east side of the Oval Office, had one of these locator boxes, and Mr. Haldeman had a third. I believe there was a fourth in Mr. Chapin's office. In fact, I'm sure there was a fourth in Mr. Chapin's office. We were probably the four who would be most concerned, or at least most immediately concerned, with the President's whereabouts or the fact that he was changing locations. In that, the Oval Office and the Executive Office Building office were indicated on this locator box. The installation was installed in such a way that when the light was on Oval Office, the taping device was at least triggered. It was not operating, but it was triggered. It was spring-loaded, if you will. And then it was voice-actuated. So when the light was on Oval Office, in the Oval Office and in the Oval Office only, the taping device was spring-loaded to a voice-actuating situation. When the President went to the EOB office and the light was on EOB office, there was the same arrangement. For those two offices, the arrangement was the same, and the taping picked up all conversation or all noise in those two offices when the light was at those positions.
We've discussed the Oval Office and the EOB office. What about the Cabinet room? Was there a taping device in the Cabinet room?
Yes, sir, there was.
Was it activated in the same way?
No, sir, it wasn't, and my guess is, and it's only my guess, is that because there was no Cabinet room location, per se, on the locator box, there was only a West Wing indication. When the light was on West Wing, that meant the President was in one of two places, the Cabinet room or the barber shop. When he went into the Cabinet room, the light went to West Wing. But he could have been someplace else in the West Wing, and so to ensure the recording of business conversations in the Cabinet room, a manual installation was made.
I don't want to hurry you, Mr. Butterfield, but I understand there's a vote in about 12 minutes, so if we could go through it rather rapidly the first time, we might come back and pick up some of the loose ends. I understand the recording device in the Cabinet room was manually operated then. Is that correct?
That's correct.
Were there buttons on the desk in the Cabinet room there that activated that device?
There were two buttons.
Was there also, pardon me, was there also an activating device on your telephone?
Yes, sir. There was an off-on button, or one that said Haldeman, one that said Butterfield. That was on and off, respectively, and one on my telephone.
How was the device usually activated, by the buttons or by your telephone activator?
To my knowledge, the President did never pay any attention to the buttons at the Cabinet table. It was activated by the button on my telephone by me.
All right. As far as the Oval Office and the EOB office is concerned, would it be your opinion that those devices would pick up any and all conversations, no matter where the conversations took place within the room, and no matter how soft the conversations might have been?
With regard to the Oval and EOB offices? Yes, sir. It's my...
Was it a little bit more difficult to pick up in the Cabinet room?
Yes, sir. It was a great deal more difficult to pick up in the Cabinet room.
All right. We've talked about 3 rooms now, and if I could move on to telephones. Are you aware of the installation of any devices on any of the telephones? First of all, the Oval Office.
Yes, sir.
What about the Executive Office Building office of the President?
Yes, sir. The President's business telephone at his desk in the Executive Office Building.
What about the Lincoln Room?
Yes, sir. The telephone in the Lincoln sitting room in the residence.
What about Aspen Cabin at Camp David?
Only in or on the telephone at the President's desk in his study in the Aspen cabin, his personal cabin.
Or is my understanding that this cabin was sometime used by foreign dignitaries? Was the device still present during those periods of time?
No, sir. The device was removed prior to occupancy by chiefs of state, heads of government, and other foreign dignitaries.
All right. Did you state who installed these devices, all of these devices, as far as you know?
I didn't say, no, sir.
Well, who did?
The Secret Service, the Technical Security Division of the Secret Service.
All right. And you alluded to what you stated as the reason for the installation of these devices. Did you state why, as far as your understanding is concerned, these devices were installed in these rooms?
Well, there was no doubt in my mind that they were installed to record things for posterity, for the Nixon Library. The President was very conscious of that kind of thing. We had quite an elaborate setup at the White House for the collection and preservation of documents and of things which transpired in the way of business of state.
On whose authority were they installed, Mr. Butterfield?
On the President's authority by way of Mr. Haldeman and Mr. Higbee.
Did the President instruct Mr. Haldeman, and Mr. Haldeman instruct Mr. Higbee, who in turn instructed you?
Mr. Haldeman instructed Mr. Higbee to tell me, and as I said earlier, I was the liaison with the Secret Service. It would be proper for me to give the instruction to the Secret Service.
During your tenure at the White House, as far as your own knowledge is concerned, who else knew about the presence of these recording devices?
The President, Mr. Haldeman, Mr. Higbee, and I. Plus the Secret Service people who I would prefer not to name in this public hearing, and that this kind of thing is a part of their profession, and I'm not sure the correctness of that statement or the propriety of refusing.
What other non-Secret Service personnel besides those you have mentioned now know of those devices?
When I departed, there was one other. My secretary knew also. At this time, although she was not informed early on, she was informed much later, because there were a number of occasions on which I just could not be there to press this button, and I briefed her and asked her to do it for me, but she did not have any idea of the extent of this. I think she was only aware of the cabinet room. Perhaps she was aware of the Oval Office. When I departed, I was authorized to brief Steve Bull, who now occupies that office and now has many of the responsibilities that I had. General Haig, who is sitting at Mr. Haldeman's desk, knows, and I believe that's all, sir.
As far as you know, did Mr. Ehrlichman or Mr. Dean know about the existence or the presence of those devices?
That would be very unlikely. My guess is that they definitely did not know.
Where were the tapes of these conversations kept and maintained?
I cannot say where. I'm quite sure in the Executive Office building, in some closets or cupboards or files which are maintained by the Technical Security Division of the U.S. Secret Service.
Were these tapes checked periodically?
Yes, they were checked at least daily. They were, I think some were used more frequently than others. Of course they were. The Secret Service knew this. They made sure that they were checked periodically and sufficiently too.
Do you know how many conversations or how many days would be represented on one particular tape?
No, sir, I do not. There were a number of days during which the President was not at the White House, so or the business was light, and there were the days the business was exceedingly heavy. I couldn't say.
Did you ever hear any of these tapes being played?
Yes, sir, I did. It was my duty to ensure that the equipment was working properly. I checked the Oval Office, EOB office, cabinet room tapes several times, and as I told you earlier, it was always working properly in the Oval Office and the EOB office. It was very, very difficult to pick up conversation in the cabinet room, and I never did check any of the telephones.
Were any of these tapes ever transcribed, as far as you know?
I didn't hear you, sir.
Were any of these tapes ever transcribed, reduced to writing or typewritten paper, as far as you know?
To my recollection, no.
Was there ever any discussion of transcribing any of these tapes?
To my recollection, no, sir.
Well, you mentioned that they were for historical purposes. Was there ever any discussion about going ahead and catching up on the tapes that you had previously recorded?
Well, by discussion, I was thinking of discussion by others. On at least one occasion, not in necessarily a serious vein, but in very offhand, rather casual conversation to Mr. Haldeman, I did say that we should go ahead and get a leg up on the transcribing of these tapes, and that the storage problem was getting to be quite fantastic. And eventually they had to be transcribed for the Nixon Library, and it was my suggestion that we get 3 or 4 or 5 highly trustworthy secretaries and begin the typing, so that at the end of the Nixon term we'd at least have a year and a half, or 2 years out of the way.
Did you talk to any of the Secret Service agents when they went about installing these devices in the various offices?
Did I talk to them when they went about the installation?
Yes. Were you present during the installation?
Oh, no, sir, I was not. I simply gave the instruction in my office immediately after I was asked to do just that.
Did they indicate that they were familiar with how they should go about installing these devices?
There was sort of the intimation that they were, yes, sir. But that's very definitely my interpretation of that. No one said that to me.
Would it be an intimation that they had done this before?
I have heard that rumored, and together with the intimation on this occasion I mentioned, I assume that it has, but I certainly don't have any proof, far from it.
All right. Mr. Butterfield, as far as you know, from your own personal knowledge, from 1970 then until the present time, all of the President's conversations in the offices mentioned and on the telephones mentioned were recorded, as far as you know.
That's correct, until I left. Someone could have taken the equipment out, but until the day I left, I'm sure I would have been notified.
And as far as you know, those tapes are still available?
As far as I know, but I've been away for 4 months, sir.
I have no further questions.
Mr. Butterfield, just a few questions, because I think Mr. Thompson's questions have pretty much elicited most of the testimony. I think what you're saying was that at all times, certainly in the White House itself, either in the Oval Office or if in the executive office of the President, where there was a locator light, that whenever the President moved and the locator light moved to where the President was, it triggered the microphones. And then whenever anybody started to speak in that office where the microphones were, as a voice-activated device, the recording device began to operate. Is that not true?
That is true, yes, sir.
Now, when someone finished speaking, would it stop at that point, or would there be some lag picked up to pick up an answer?
It was explained to me by those who installed the equipment that the equipment allowed for a lag so that no portion of a conversation would be omitted. So if I were talking to you and stopped talking just momentarily, the tape would not stop. It would continue for a moment or two so that it would pick up your response if you should respond immediately.
Now, is your understanding that this operated on an ongoing basis daily? This system operated on an ongoing basis daily?
Yes, sir.
To your knowledge, did the President ever ask, while he was in the Oval Office, to have the system not operate, the locator light not show in that office so as to trigger the device?
No, sir. As a matter of fact, the President seemed to be totally, really oblivious, or certainly uninhibited by this fact.
Well, at least he authorized it to be installed in the first place, and thereafter, as you say, he has not paid any attention to it.
That's true, sir.
And by not paying attention to it, that meant that the device was working at all times.
Yes, sir.
And this is true in the cabinet room, where you said that the President could, by switch, actually turn it off. As a matter of fact, it was you who, or your secretary, whenever there was to be a cabinet meeting, would see to it through the button on your phone that the microphones were activated.
I don't want to involve my secretary to that extent. I did it all the time, and I think only on one occasion I had to call in and ask her to go to my phone and push a certain button that I described, and it was most mysterious to her, and at a later date I explained what I had meant and asked her to say nothing, and I'm sure that she never did.
Now, the tapes which you've mentioned, which are stored, are they stored by particular date?
Yes, sir, they are.
And so that if either Mr. Dean, Mr. Haldeman, Mr. Ehrlichman, Mr. Colson had particular meetings in the Oval Office with the President on any particular dates that had been testified before this committee, there would be a tape recording with the President of that full conversation, would there not?
Yes, sir.
Now, who authorized you to brief Mr. Bull when you left your employment in the White House?
I went into Mr. Haldeman and pointed out the necessity for briefing Mr. Bull. He was going to occupy my office. In fact, he did occupy my office, 2 to 3, maybe even 4 weeks prior to my being sworn in at the Federal Aviation Administration. Mr. Haldeman understood the wisdom or the necessity for that and told me to go ahead.
Now, I think the only part of this system which is removed from time to time, as I think you've testified, is that at Camp David, which is removed when foreign dignitaries or heads of state are present. And I take that as for national security purposes.
That is true, yes, sir. Right. That is certainly my understanding.
Right. Now, I'm not sure whether you testified to this, but you tested the system at one point, did you not? To
yes.
See, certainly in the Oval Office or the EOB office, that you could pick up sound, even though it was hardly audible when the sound was made in the room.
Yes. And
what was the result of your test?
The result was that voices, conversations were picked up very well, very clearly.
Even if there was a whisper?
In the Oval Office and in the Executive Office building. I can't tell you about a whisper. I just don't know, but it would appear that even low tones were picked up well. In the cabinet room, some voices, those who spoke up quite loudly, could be heard. Anyone who had the habit of speaking softly could not be heard very well at all. In fact, you could not begin to get most of the conversations.
Now, with regard to the telephone taps, they were operated, were they not, by as soon as the President, who may have used his telephone, lifted up his telephone and engaged in a conversation or received a conversation on his President's phone, the recording device began to record the telephone conversation.
That's my understanding, Mr. Dash, but I lack all of the technical knowledge of the telephone recording device.
But so far as you know, all telephone calls were also recorded?
From the President's office telephone
yes.
on his desk in the Oval Office
yes.
and his regular office phone in the Executive Office building and the desk telephone in his study at Camp David and his telephone in the Lincoln sitting room. Those 4 phones.
One last question. If one were, therefore, to reconstruct the conversations at any particular date, what would be the best way to reconstruct those conversations, Mr. Butterfield, in the President's Oval Office?
Well, in the obvious manner, Mr. Dash, to obtain the tape and play it.
I have no further questions, Mr. Chairman.
The questions of counsel And the answers of the witness have been so clear, I have no questions.
Mr. Chairman, I have only one brief question. Mr. Butterfield, it's my understanding that on an interview this past Friday, as pointed out by Mr. Dash, that you volunteered this information in response to a question put by minority staff about how certain information supplied by the White House might have been so exact. And some query was made about whether or not Mr. Dean might have thought there was a recording device. And my understanding is that you at that time said that there are recording devices in these offices. Is that essentially the situation as it transpired in your interview on last Friday?
Yes, that's essentially correct. As they led up to the question, I said nothing. When asked the direct question, I answered openly and freely. With regard to the query concerning Mr. Dean's suspicions, my guess was that that was his imagination only. I am sure that the President would not lead Mr. Dean to off to the side. The President seemed completely unaware of these. I'm sure that he forgot them from time to time, or perhaps for long periods of time.
The point I'm leading up to is this, Mr. Butterfield. You have, in fact, been very straightforward in your answers in the interview and the interview just before this hearing, and I think now in your testimony. But just so that we're entirely clear on the matter, you have notified counsel for the White House of your interview and of your testimony, what you're going to testify here today.
Yes, sir, I have.
And was there any intimation to you that executive privilege should be claimed on your part?
No, sir, there was not.
Now, Mr. Butterfield, you're here under subpoena. You're here at the request of the committee. And for my part, I think you've been most helpful, and we thank you for your forthright statement. Thank you, Mr. Chairman.
I would like to make one statement before we adjourn, unless...
I think there may be some other questions of some of the members of the committee.
I should be quite brief, Mr. Chairman. Mr. Butterfield, I understood you to say that all calls to the White House of whatever nature and character would be taped. Is that an accurate statement?
Into those telephones, to and from those telephones I mentioned, yes, sir, that's an accurate statement.
A senator, a congressman, or a governor called, it was taped.
Yes, the tape would not discriminate.
Was any warning signal to let them know the conversation would be taped?
Again, I'm not aware of the technical details. I'm told that when devices are on telephones, there's oftentimes a clicking sound, but other than that, I would guess that no one would be aware, sir.
No one verbally volunteered, Governor, your telephone conversation will be taped, did they?
No, sir.
Or senator, or congressman, or Mr. Private Citizen, as the case may be.
No, sir.
Now, were the visitors that went into the White House warned that their conversations with the President would be taped?
No, sir.
None of them had knowledge that their conversations were being taped.
No, sir, although I would say one thing, which I think perhaps should be said at this point. When people go to visit the President, almost always, I know of very, very few exceptions, a staff member sits in on the conversation, often takes notes. It's standard procedure in order to record commitments made by the President, at least the thread, the substance of the business discussed, and that, of course, does go into the presidential papers.
Now, when the President left the White House, were his conversations with others taped also?
Senator Talmadge, I didn't hear you, sir.
When the President left the premises of the White House, were his conversations with other people taped?
No, they were not, sir.
Do you know whether or not the Attorney General of the United States approved the recording of these telephone and verbal conversations?
I have no idea, sir.
If any call was made from one official in the White House to another one, Mr. Haldeman to Mr. Dean, or Mr. Dean to Mr. Ehrlichman, was that also taped?
Not to my knowledge, sir. I have no knowledge of any other taping devices at all.
Only the conversations with the President by telephone and in his presence. Is that an accurate statement?
To and from those specific
And the reason for this tape, insofar as you know, was solely to serve historical purposes.
I'm sure of that, yes, sir.
If no staff member was there, would a party be told that the conversations were taped?
No, the party would not, sir, under normal procedure.
Thank you, Mr. Butterfield. Mr. Chairman, I have no further questions.
I have one or two. Where the technical details of this, where were the recording machines kept? Do you know?
At least most of the recording machines were in the basement of the West Wing of the White House.
And who was in charge of those?
The chief of the Technical Security Division of the U.S. Secret Service.
And did the chief or someone under his direction handle the changing of the tapes and the putting them on, the taking them off?
Yes, sir.
And also the storage?
Yes, sir.
Did anybody else handle those to your knowledge?
I am as sure as I know I'm sitting here that no one else would have handled the tapes other than this individual I mentioned, the chief of the Technical Security Division, and the 2 or 3 people designated by him. And it was...
What about in Key Biscayne and San Clemente, the Florida and Western White Houses? Were there any recording devices there to your knowledge?
Not to my knowledge or recollection. I do not recall any instructions being given with regard to those locations, sir.
And what about on the business phones in those 2 locations?
No, sir.
I don't have
At least not through me, sir.
Don't have any other questions, Mr. Chairman.
Just one question, sir. Do you have any information to indicate that this taping was practiced in other administrations?
Well, in all honesty, Senator Noye, I have heard the rumor. I could not begin to identify the source, but I've heard those rumors for several years. And on the occasion which I described earlier, at the time that I called in the Secret Service people and gave them this particular instruction, there was the intimation, there was the, by their gestures or by their response to me, that they knew how to proceed. And from that, I would guess that it had been done, but I am only guessing when I say that.
I thank you very much, sir.
Hold on.
Amendments to that bill on the Alaskan pipeline continue to divert the senators' attention from the committee hearing. After a brief pause, the senators resumed their probe into that secret recording apparatus at the White House.
Committee will resume business. Senator Weicker was the next, but I don't beat it in, so I'll go to Senator Montoya at this time. Recognize Senator Weicker when he comes in.
Thank you, Mr. Chairman. Mr. Butterfield, was there any mechanism available whereby the President could turn off the recording in the Oval Office or in the Executive Office?
No, sir.
In other words, it was not within the power of the President or anyone working under him in those particular offices to turn off this recording?
No, sir, but technically speaking, one could order that the locator light be moved, even though the President might be in that position, but that would not happen under normal circumstances. I know of no occasion on which that happened.
Well, did you know whether anyone else had the proper mechanism to turn the recording off?
No, sir, I'm sure no one did, and as a matter of fact, I doubt if anyone other than the Secret Service members and I, perhaps I explained it to Mr. Higbee, knew how it could be turned off, or knew how it worked, as a matter of fact.
So what you're saying is that there is no possibility that any conversation in the Oval Office or in the Executive Office or in the Camp David study room could be turned off? There is no possibility of that?
No, sir, not from within those offices. They would have to instruct me to have the equipment moved, changed.
Were you ever instructed?
No, sir, I was not.
Were you able to monitor the conversations from your office?
No, sir, I could not monitor it.
All you could tell from your office was that there were conversations going on and that the machine was working. Is that right?
But I couldn't even tell that at any given time. I only had to rely on the Secret Service members to see that the tape was being used, that the equipment was operational, that the tapes were changed frequently.
Now, is there any possibility that the tapes which were collected, that some of them could be missing or could have been destroyed?
Not to my knowledge, there shouldn't be. The Secret Service are highly trustworthy. It was their responsibility to change the tapes and to store and to mark the tapes and to store them.
And who had responsibility for the storage, for the removal and the storage of these tapes, besides yourself?
Well, I ultimately, but the director of the Technical Security Division was given that responsibility by me, and he carried it out.
Was he the only one besides yourself?
He and those who worked for him.
Did Mr. Ehrlichman or Mr. Haldeman or anyone else who worked for the President have authority to go into this particular room where the tapes were stored?
Mr. Haldeman had authority to do anything in the White House, sir, in that he was, in effect, the chief of the staff. It would be very unlikely for him to do that. He entrusted the responsibility to me. Mr. Ehrlichman, to the best of my knowledge, and I feel quite certain of this, knew nothing about the tapes.
Were the tapes properly labeled to indicate what conversations were contained therein?
Nothing about the conversations in the Secret Service, and again, I say that I trust them implicitly, did not listen to conversations. They, too, however, would check to make sure that the equipment was picking up sound. They would make a quick check on that and ensure that it was picking up sound from time to time. And I made more elaborate or extensive checks on about 3 occasions.
And you state that the tapes were primarily to record conversations within these particular offices so that we could preserve history for posterity?
Yes, there really is no question in my mind about that, Senator Montoya. Right. That was often on the President's mind, and as I said, he was very conscious of our having a good system for collecting the things which transpire with regard to the affairs of state.
Then why, Mr. Butterfield, wasn't anybody recording history at Key Biscayne or at San Clemente or at other places? Why was that gap, why the gap there?
I can't answer that question, except that when the President did go to Key Biscayne and to Camp David, he was going principally for the reason of resting and relaxing. Those are resorts. The Western White House, admittedly, is truly a Western White House. It's the Western extension, and I cannot answer your question with regard to it. It's a gap.
Was there ever any discussion on trying to fill this gap?
There may have been. I'm very foggy on that. There may have been.
To your knowledge, there wasn't?
Not to my specific knowledge. I can't say that. I have a very fuzzy recollection of a possible conversation. Perhaps we should do it out there. But when we were out there, as you may know, the schedule was relatively light. The President does work. He does see people, but he uses the time to collect his thoughts and lay out plans and that sort of thing. So whereas there is a gap, I would not say it's a serious one.
That's all, Mr. Chairman. Thank you.
Senator White, I'm sorry you were out a while ago when we resumed, and so I was calling on Senator Montoya. I now accord you an opportunity to examine the witness.
Thank you, Mr. Chairman. Just, Mr. Butterfield, just 3 very brief questions. As I understand, the listening devices in the Oval Office and in the EOB were activated in two ways. They were activated, number one, by the presence of the President, and then number two, by voice. Is that correct?
That's correct. You're being properly technical.
Right.
The President had to be there. If he weren't, the locator light would not indicate.
So that it would not, unless you have specific information to refute my supposition on this matter, no one other than the President could be in one of these rooms and have the conversation taped.
No, no one could. I was often in the Oval Office with Mr. Bull discussing plans, or the cleaning people are in there at night. None of that is picked up because the indicator light is indicating residence or out or wherever the President might be.
You know, it's a two-step system, and both steps have to be in place before the taping starts.
Yes, sir. With regard to the Oval Office and the Executive Office Building Office.
Now, insofar, well, let me just ask this question: Would any other area? I'm trying to think what the other areas were that you mentioned. Camp David. I'm talking about the listening devices, not the phone.
The cabinet room only, sir.
And the cabinet room. In the cabinet room, would it be possible for conversations in the cabinet room to be taped without the President's presence?
Yes. By pushing one of the buttons under the table, the one on the left on the outboard side was the on button. The button on the right on the outboard side was the off button. Also by pushing a button on my telephone. I've frankly forgotten whether it was one button you pushed on and it lit and you pushed it again and it went out, or whether there were two buttons, but it was an unmarked button on my telephone face, and it was a large telephone with many buttons.
Do you know of any instance when this did occur, a taping of conversation held in the cabinet room without the President present?
No, sir. As a matter of fact, on a number of occasions at cabinet meetings, and I know this from first-hand knowledge in that I sat in on all cabinet meetings except those few executive sessions which were held, no more than 2 or 3 in the 4-year period, the President would leave the cabinet room. And the cabinet meeting would continue under the chairmanship of the Vice President, perhaps, or under the chairmanship of Secretary Rogers. As a general rule, I would leave, too, if the President left. My concern was the President's concern. I had no real business remaining if he were not there, and I would go back to my office and push the off button, and we would stop recording. It was only for the President's business, and that again supports my earlier guess, really, but I feel certain knowledge that it was purely for historical purposes.
Now, insofar as the listening devices on the telephones are concerned, they, however, did not need any two-step procedure. Is that correct?
That's correct, sir.
In other words, that as soon as one got on the telephone, that activated the system.
Those specific telephones, yes, sir.
And it could be someone other than the President. In other words,
on one of his telephones, yes, sir.
Both parties to the conversation, neither one of them would be the President of the United States, and the conversation would be taped.
That's correct. But there again, sir, I would remind you, and you may know this already, or I'm sure you've guessed it, it would be highly unlikely that someone would be sitting in his chair in the Lincoln sitting room or at his desk in either of those offices or at his study at Camp David.
Now, why do you feel that this system was installed in 1970? If in fact it was installed for historical purposes, wouldn't it have made a great deal of sense to have this done right at the outset of the administration?
It would have made a great deal of sense, but frankly, it was not thought of. I'm sure that's the reason. I'm speaking for other people when I say that. but I feel certain that was the reason. A great many things evolved, a great many systems evolved. We had a system for preserving records of what transpired in the President's meetings. These memoranda were called Memoranda for the President's File. And when I spoke to either Senator Talmadge or Senator Inouye a moment ago about, or whoever it was, I'm not sure, about our procedure for having a staff member sit in on all calls on the President. The President was never alone with anyone who might call on him. It might be his old Duke Law School professor, but someone would sit in on that meeting and preferably make mental notes of what transpired, because actually writing notes had a tendency of inhibiting the guest, and we didn't want to do that. But the point I am making is, as much was remembered and as much was recorded, at least mentally, as possible during the meetings, and afterward spit out into a dictating machine and written up in any manner whatsoever. We didn't care about punctuation. We didn't care about grammar. We just wanted the substance of what transpired in that meeting for a special file, which was called Memoranda for the President's File. And we didn't think of that at the outset of the administration. And I think it was, I think we were about into the first year. It was roughly January or February of 1970 when we began that procedure. So it was just a case of evolution, sir.
Now, in the interview which you had with the staff of this committee, which interview I gather took place on July the 13th, 1973 at 2:15 p.m. The interview, as reported by this staff, concludes with, and I'd like to have your comments on this matter, Butterfield stated, quote, "This is all something I know the President did not want revealed, but you asked me, and I feel it's something you ought to know about in your investigations. I was told no one was to know about the information. I have told you," end of quote. Is that a correct quotation?
I couldn't say that it was correct, but there was some reluctance on my part to reveal information which I felt could have a number of serious repercussions with regard to foreign governments. It is very obvious that this could be, I can't say that any longer, is embarrassing to our government, and also because I felt it could be something the President would like to present at a later time in defense of his own position.
Did anybody indicate to you that you shouldn't reveal it?
No, sir.
Have you had any conversations with
anyone?
anyone?
To say quite the contrary, but I won't say quite the contrary. No one has contacted me at all. I was telephoned on, I forget the date, but roughly early April, it might have been mid-April, by Mr. Higbee, and who said, not that I needed to be reminded to be totally truthful, but who said that be sure you tell the truth, or words to that effect, the whole truth and nothing but the truth whenever you are called upon to testify. And I must say I resented slightly his telling me that, but I know Larry well, and I didn't really, and I said, of course I will. So I've had no instructions to the contrary. I do feel that I am lacking in knowledge of judicial procedure. I do feel that I'd have perhaps done better if I had had counsel. I just don't know. But I would not want to be, I might say too that I knew when I was interviewed on Friday afternoon that those same staff members of yours had interviewed Mr. Haldeman and Mr. Higbee. I knew that they had complete knowledge of this. My assumption was that they had been asked the same questions precisely, and my assumption, of course, was that they had answered openly and honestly. So I say I was a bit reluctant, only because of the import, but obviously not so reluctant that I failed to answer.
Well, I just want to thank you very much, Mr. Butterfield. Let me say something right now. You don't need counsel, and let me also say you don't need any of those assumptions which you've just given me. You've got the greatest thing going for you, which is you've told the truth to the committee. Thank you very much, Mr. Chairman.
This committee has taken some testimony to the effect that one Tom Charles Houston was appointed to conduct a study for the White House in the summer of 1970. Do you know anything about that? That is your own knowledge. I'm not asking what you read or may have read.
Yes, I do, sir.
Yeah.
Very little, and I can remember even less. But
that preceded the installation of these listening devices and telephone equipment, didn't it?
Oh, I couldn't begin to say, Senator Ervin, and I myself would not tie the two together.
Wouldn't the fact that this was all so much under the custody control of the Secret Service indicate that these tapes were not for present public dissemination?
Yes, it would indicate that.
Yes. I want to thank you very much on behalf of the committee for the... Yes.
May I ask one or two more questions?
I'll read this.
Mr. Butterfield, where are the records kept that show where the tapes can be found? For example, if you wanted to find one of a certain date, is there a file book or a file record on these tapes?
If there is, Senator Gurney, it is maintained by the Technical Security Division of the Secret Service. On those few occasions on which I checked tapes to see if they were working and that conversation was coming in clearly, I simply called the chief of that office and spoke only to him and said, send me a tape from the Oval Office. I didn't specify a date. I had no, just send me one. And I proceeded to check it. And as I say, I did that only about 3 times.
Do you know of your own knowledge whether anyone has ever sought to get any of these tapes or has gotten any of these tapes other than yourself in the testimony that you have just given this committee?
No, sir. If Mr. Haldeman wanted to do that, he could call the same individual, the chief of the Technical Security Division, and ask him to bring a tape over or whatever and not inform me. And of course the Secret Service agent would do that. But all of that was channeled through me. I feel certain that Mr. Haldeman would not have done that. And under any normal circumstances, should anyone else do it, I would have been notified. And the Secret Service would not have responded, in fact, until I had given my approval.
Now, is it your testimony that if anybody had ever asked the Secret Service for these tapes, that they would have notified you?
Yes, that's correct.
And that has never occurred, is that correct?
Yes, only if it had been someone senior to me, and there were a number of these people, but the only one senior to me who knew of this was Mr. Haldeman, other than the President. If they instructed someone not to tell me, that would be the case, but I would not guess that that would happen.
In any event, the person to find out about the records and how they were kept and where they are kept and who has had access to these tapes is the chief of the Technical Service of the Secret Service.
Yes, sir.
Thank you.
He would know.
The chair has received a letter from Mr. J. Fred Buzzard, counsel for the President, dated July the 16th, 1973, reading as follows. Dear Mr. Chairman, this letter is to confirm the facts stated to your committee today by Mr. Alexander Butterfield, that the President's meetings and conversations in the White House have been recorded since the spring of 1971. I am advised that this system, which is still in use, is similar to that employed by the last administration, which has been discontinued from 1969 until the spring of 1971. A more detailed statement concerning these procedures will be furnished to the committee shortly. Sincerely, signed J. Fred Buzzard. Mr. Butterfield, on behalf of the committee, I want to commend you for the forthrightness of your testimony, and thank you very much.
Thank you, sir. I will be the first to agree with Mr. Buzzard. I only guessed at the time. That is pretty good evidence, I think, of how fuzzy one's recollections can be, to be off a full year. But if they say the spring of 71, obviously that's been checked with the Secret Service, who would have a record, and I stand corrected on that point. I have one closing statement. I've really said this at one point in my testimony, but I would feel better if I were allowed to say it once again. In accordance with White House instructions, and by that I mean the telephone call I mentioned to you, Senator Weicker, from Mr. Higbee, and again, I might say not that I needed any instructions on the matter of honesty. I have freely and willingly appeared for interviews and answered all questions put to me, not only honestly, but openly. This matter, which we have discussed here today, I think, is precisely the substance on which the President plans to present his defense. I believe, of course, that the President is innocent of any crime or wrongdoing, that he is innocent likewise of any complicity. And certainly that is so in the face of the kinds of evidence and exhibits, at least that I know about, which have been put before this committee to date. I knew when I was interviewed by your staff members on Friday afternoon, as I said earlier, that Messrs. Haldeman and Higbee had preceded me in separate but similar interviews. I certainly assumed that each had given an open and honest answer to that particular question, and that I was being asked that same question so as to corroborate the fact, or by that I mean their answers. I only hope that I have not, by my openness and by my adherence to all instructions received to date, given away something which the President planned to use at a later date in support of his position. That's all I have, sir.
Well, thank you very much. Thank you very much.
So, Alexander Butterfield has lived up to his advance billing as a surprise witness with a vengeance, and the committee now can be far more specific in its request for White House documents, and an indication also we've got that the President plans to defend himself. Public television's coverage of the Senate hearings will continue after a pause for station identification.
Unabridged coverage of these hearings is provided as a public service by the member stations of PBS, the Public Broadcasting Service. From Washington, NPAC continues its coverage of hearings by the Senate Select Committee on Presidential Campaign Activities. Here again, correspondent Robert McNeil.
As we go back to the hearings, the committee is about to call Nixon fundraiser Herbert Kalmbach to the stand.
The counsel will call the next witness.
Will Mr. Herbert Kalmbach take the come to the witness table, please?
Mr. Kalmbach, will you stand up and hold up your right hand, please? You swear that the evidence which you shall give to the Senate Select Committee on Presidential Campaign Activities shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Suppose you state your name and address for the record and profession for the purposes of the record.
My name is Herbert Warren Kalmbach. My address is 1056 Santiago Drive, Newport Beach, California.
Now, the chair notices that you are accompanied by a counsel and requests the counsel to state his name and address for the purposes of the record.
Thank you, Mr. Chairman. My name is James H. O'Connor, Phoenix, Arizona.
Thank you.
Mr. Kalmbach, you have prepared, I know, a brief statement. Would you like to read that statement to the committee?
Yes, Mr. Day.
Would you please do so?
Thank you. Mr. Chairman, Mr. Vice Chairman, and members of the Senate Select Committee, prior to the time this committee began to take testimony in this matter and before the issuance of a subpoena, I voluntarily appeared and offered to testify to whatever knowledge I had that would be helpful to the committee in its investigation. My decision to do so was prompted by the chairman's remarks to the Senate on February 6, 1973, and by my desire to clear my name of any suggestion of improper activity with respect to events leading up to or following the so-called Watergate break-in on June 17, 1972. Also, for the record, I wish to state that I have never asked for immunity, nor have I indicated that I would exercise my Fifth Amendment rights before this committee or any other investigative body relative to the subject of this inquiry. Even though I have earlier submitted copies of my personal resume to the committee's staff for distribution, a brief summary of that biographical statement may be appropriate for the purposes of this opening statement. I was born in Michigan in 1921 and moved with my family to California at an early age following the death of my father in 1932. I was raised in Southern California and spent almost 5½ years on active duty in the Navy during World War II. I completed my undergraduate work and law school education at the University of Southern California in 1951. It was at law school that I first met my old and close friend, Jim O'Connor, who has been acting as my counsel in this matter. Since graduating from law school, I've been active in the practice of law and in corporate management work in Southern California and in Arizona. In 1967, the present firm of Kalmbach, DeMarco, Knapp, and Chillingworth was founded with offices in Los Angeles and Newport Beach. Also, for more than 20 years, I've been active in political work, particularly in recent years in the area of campaign finance. Since early 1969, I've been engaged in activities on the President's behalf in 3 major areas. First, it has been the source of great pride and personal satisfaction to me and to my partners to have had the responsibility for handling personal legal matters for President Nixon and members of his immediate family for the past 4 years. During this period, practically all of the contacts that I had relative to these matters were handled through either John Ehrlichman or John Dean. Second, I acted as trustee during the period from January of 1969 to early February of 1972 for certain surplus funds which had accrued principally from the primary campaign of the primary period of the 1968 campaign. While Maurice H. Stans was the individual with whom I dealt at the time I accepted such trusteeship, I disperse from such funds only at the express direction of H.R. Haldeman or others clearly having the authority to direct such disbursements. Third, I agreed to solicit early pledges of financial support for the President's 1972 campaign beginning in November of 1970. This assignment was completed in the spring of 1972. The original records of this activity were turned over to the Finance Committee after Mr. Stans had assumed the post of Finance Chairman on February 15, 1972. I thereupon directed my secretary to destroy my files, which were wholly personal and supportive of the original files earlier transferred to the Finance Committee. This action on my part was intended to ensure the continued confidentiality of the contacts that I had had with various contributors with whom I had dealt during this period. Copies of what remaining records I have and such bank records as I have been able to retrieve have been supplied to the committee staff prior to my appearance here today. Finally, I want to take this opportunity to deny any prior knowledge of the Watergate break-in or participation in the formulation of any planned conspiracy to cover up that incident or acts of campaign sabotage or unethical activity. My actions in the period immediately following the break-in, which involved the raising of funds to provide for the legal defense of the Watergate defendants and for the support of their families, were prompted in the belief that such was proper and necessary to discharge what I assumed to be a moral obligation that had arisen in some manner unknown to me by reason of earlier events. The fact that I had been directed to undertake these actions by the number 2 and number 3 men on the White House staff made it absolutely incomprehensible to me that my actions in this regard could have been regarded in any way as improper or unethical. I'm here before you today to tell the truth about my activities during the period in question. It is not my purpose to testify for or against any individual. I wish to cooperate fully with the committee, and in that spirit, I am now ready to answer your questions to the very best of my ability. Thank you.
Thank you, Mr. Kalmbach. Mr. Kalmbach, when did you first meet President Nixon?
It was in the mid-50s, Mr. Dash.
Now, there came a time, did there not, that you played a role in campaign fundraising for the president? When was that? Prior to the 1972 campaign.
In 1968, I was Associate Finance Chairman for that campaign.
Now, what, if anything, did you do with any funds left over from the 1968 campaign?
Mr. Stans, in mid-January of 1969, asked me to accept the trusteeship for certain surplus funds from that campaign.
And where were those funds kept?
Prior to that time, they'd been kept in New York. I'm not certain as to exactly where in New York.
And these would be in safe deposit boxes?
Yes, sir.
Who could authorize, Mr. Kalmbach, disbursements from these funds?
Mr. Haldeman, principally. At a later time, also Mr. handling personal legal matters for President Nixon and members of his immediate family for the past 4 years. During this period, practically all of the contacts that I had relative to these matters were handled through either John Ehrlichman or John Dean. Second, I acted as trustee during the period from January of 1969 to early February of 1972 for certain surplus funds which had accrued principally from the primary campaign of the primary period of the 1968 campaign. While Maurice H. Stans was the individual with whom I dealt at the time I accepted such trusteeship, I dispersed from such funds only at the express direction of H.R. Haldeman or others clearly having the authority to direct such disbursements. Third, I agreed to solicit early pledges of financial support for the President's 1972 campaign beginning in November of 1970. This assignment was completed in the spring of 1972. The original records of this activity were turned over to the Finance Committee after Mr. Stans had assumed the post of Finance Chairman on February 15, 1972. I thereupon directed my secretary to destroy my files, which were wholly personal and supportive of the original files earlier transferred to the Finance Committee. This action on my part was intended to ensure the continued confidentiality of the contacts that I had had with various contributors with whom I had dealt during this period. Copies of what remaining records I have and such bank records as I have been able to retrieve have been supplied to the committee staff prior to my appearance here today. Finally, I want to take this opportunity to deny any prior knowledge of the Watergate break-in or participation in the formulation of any planned conspiracy to cover up that incident or acts of campaign sabotage or unethical activity. My actions in the period immediately following the break-in, which involved the raising of funds to provide for the legal defense of the Watergate defendants and for the support of their families, were prompted in the belief that such was proper and necessary to discharge what I assumed to be a moral obligation that had arisen in some manner unknown to me by reason of earlier events. The fact that I had been directed to undertake these actions by the number 2 and number 3 men on the White House staff made it absolutely incomprehensible to me that my actions in this regard could have been regarded in any way as improper or unethical. I'm here before you today to tell the truth about my activities during the period in question. It is not my purpose to testify for or against any individual. I wish to cooperate fully with the committee, and in that spirit, I am now ready to answer your questions to the very best of my ability. Thank you.
Thank you, Mr. Kalmbach. Mr. Kalmbach, when did you first meet President Nixon?
It was in the mid-50s, Mr. Dash.
Now, there came a time, did there not, that you played a role in campaign fundraising for the president? When was that? Prior to the 1972 campaign.
In 1968, I was associate finance chairman for that campaign.
Now, what, if anything, did you do with any funds left over from the 1968 campaign?
Mr. Stans, in mid-January of 1969, asked me to accept the trusteeship for certain surplus funds from that campaign.
And where were those funds kept?
Prior to that time, they'd been kept in New York. I'm not certain as to exactly where in New York.
And these would be in safe deposit boxes?
Yes, sir.
Who could authorize, Mr. Kalmbach, disbursements from these funds?
Mr. Haldeman, principally. At a later time, also Mr. Ehrlichman, Mr. Mitchell, and others who were clearly standing in the shoes of those people.
Would that include Mr. Strawn and Mr. Caulfield at all?
Yes, sir, it would.
Now, when did you begin working as the President's personal attorney?
Beginning in March, I think it was, in 1969.
And would you please describe the types of legal matters in which you and your firm worked for the President?
Well, initially, the work had to do with the acquisition of the property in San Clemente which was to become the Western White House. We have also done work on his behalf in estate planning, and also have done personal tax work in conjunction with a CPA.
Do you still work on legal matters for the President?
Yes, sir.
During this period of time now, which you've had a number of years, a relationship with the President, both in the campaign fund operation and also as his personal attorney, how often did you meet with the President?
Before this appearance here today, I've gone back over my records, and to the best of my ability, my records have shown that I have met with him probably 4 or 5 times since March of '69 alone, or with 1 or 2 others.
And did you receive telephone calls from the President?
Yes, sir.
How often would you receive a telephone call from the
Again,
President?
my records would indicate probably 4 or 5 telephone calls during that period.
Therefore, since actually during that period of time this was not a frequent contact relationship or telephone relationship, who in the White House did you have contact concerning your activities on behalf of the President?
Principally John Ehrlichman, and then after John Dean came to the White House in mid-1970, also John Dean.
Would it be fair to say, Mr. Kalmbach, that when you did speak to them on legal matters, that it was in your mind you were speaking with the President?
Yes, sir, it is.
When were you first asked to raise money for the 1972 campaign, and by whom?
It was in November of 1970 by Mr. Haldeman.
Now, what position did you have in the 72 campaign?
Beginning on February 15th of 1972, I agreed to act as the Associate Finance Chairman through the period ending April 7th, the date that the new law became effective.
Now, in February 1972, did you have funds in your possession that were raised during campaigns?
Excuse me, Mr. Dash, what was that date?
In February 1972.
Yes,
just
sir.
Prior to February.
Yes, sir.
What did you do with those funds in February 1972?
In the first few days of February of 1972, I closed all of the checking accounts that I had. One was in New York, and I believe 2 in California, and sent all of those checks to Mr. Sloan at the Finance Committee in Washington. And I also closed and emptied the several safe deposit boxes and transferred those funds to Mr. Sloan. So I zeroed out my accounts.
Do you know approximately how much money was involved in terms of turning over the money to Mr. Sloan?
Yes, sir.
How much was that?
In the first week, I would say, of February in 1972, the total was $915,000, and that total would include approximately $233,000 in cash and approximately $670,000 in checking account balances.
Now, after you turned over this money, did you destroy any records that you had?
Yes, sir, I did.
Could you tell us what records and why?
After I turned over the monies, I transferred my files on the people that I had seen, the pledges that I had received, the essentials of my records to Mr. Stans and to the Finance Committee. It was my belief then that my records that I still retained were wholly personal and supportive of what I considered to be the original records. And once I was certain in my own mind that the original records had been in fact transferred to the Finance Committee, then I directed my secretary, Mrs. Harvey, to destroy those personal and supportive records for the reason of confidentiality.
Now, these personal supportive records were bank records and checks, were they not?
There were some, yes, sir.
Now, when did you resign from your position as Associate Finance Chairman?
as of April 7th, 1972.
While you were at the Finance Committee, did you have any contact with Gordon Liddy?
Yes, sir.
Could you describe the nature of that contact or any assignments that you gave Gordon Liddy?
As best as I can recall, Mr. Dash, my first acquaintance with Mr. Liddy was in the latter part of March, although I think I had lunch with others, with Mr. Liddy in January when I first met him, but it was the first time that I really worked with him was in the latter part of March when he came aboard the Finance Committee as counsel to the committee. In my position as Associate Chairman, I gave him several assignments, asking for legal opinions and the like. And I can recall one or two trips that I asked him to take to contact attorneys for contributors to help in legal problems.
You had no contact with him or any relationship with him on any intelligence or fact-gathering operations, Mr. Liddy?
No, sir.
Now, did you give Mr. Stans an advance on his expenses in February 1972? And if so,
Yes, sir.
how much?
I gave him $50,000.
Why was that?
I beg your pardon?
Why did you give him that? Why?
Mr. Stans had come to me and asked me for these funds as an advance for personal expenses for the forthcoming campaign.
Was there a receipt given to you for that?
No, sir.
Now, are you aware of the transaction whereby $350,000 left the Committee for the Reelection of President, the Finance Committee, and went over to the White House?
I am.
Could you tell us briefly your own knowledge of how that took place?
About the last week in March, or very early in the first few days of April, and I'm not certain, I was called by Mr. Higbee from the White House and was asked as to how much cash would be available for transfer to the White House. I then checked with Mr. Sloan. I called Mr. Higbee back and told him that I'd found that there was $350,000 in cash in Mr. Sloan's safe that would be available. Then Mr. Higbee, I think there were one or two additional calls back and forth, and it's my recollection that Mr. Higbee then called and informed me that Mr. Strawn would come over to the Finance Committee and pick up the $350,000 that afternoon. And again, this was within a week of April 7th or thereabouts. I then spoke to Mr. Sloan and asked Mr. Sloan to give me the funds in time for the pickup by Mr. Strawn, which he did. And as I best remember it, Mr. Dash, the funds were put in my office in the Finance Committee. Mr. Strawn came over at 1:30 or 2 in the afternoon, I'm not certain, and picked up the briefcase from my office and then left the office.
And these funds were all in cash?
Yes, sir, they were.
You know the denominations of the bills that went over?
No, sir, I do not.
Now, you mentioned Mr. Higbee and Mr. Strawn. You're aware that Mr. Higbee and Mr. Strawn are both assistants of Mr. Holderman?
I am.
And that this request, therefore, was on behalf of Mr. Holderman?
Yes, sir.
You know what the request, why the $350,000 was needed? Was any information or any
I'm not certain that
given to you?
I'm not certain, Mr. Dash, that it was expressed to me the purpose, but I know that it was my assumption, and it may have been expressed to me, but it was my assumption that it would be used for polling purposes.
And when did this take place?
I would think within 7 days of April 7th, 1972.
Now, following Mr. Kalmbach, the break-in at the Watergate on June 17, did you receive a call from Mr. Stans asking you to come to Washington? Shortly after that period?
Excuse me, Mr. Dash, would you repeat that question?
I said following the break-in at the Watergate, which took place on June 17, sometime after that period, did you receive a call from Mr. Stans to come to Washington from California?
Yes, my recollection is that I received a call from Mr. Stans probably early in the week, the 20th or thereabouts, to come to Washington and to meet with Mr. Sloan to reconcile my cash records. There was no reference at all to the Watergate break-in.
Now, did you report to Mr. Stans after that meeting?
Yes, I did.
And what, if anything, did you say to Mr. Stans?
I just informed him that I'd met with Mr. Sloan and that we were in agreement on the cash records, and he said fine, and as far as he was concerned, I was discharged from that responsibility, and my accounts had balanced.
And did you destroy any records after the meeting with Mr. Sloan?
Yes, sir, I did. I destroyed my own personal cash record, knowing that the original record was in the finance office.
Now, on your visit to Washington on June 21 or June 22, did you discuss the Watergate break-in with anybody?
No.
It was right after that period of time.
Other than in casual conversation, I can't recall that I did, Mr. Dash.
Wasn't that a kind of a topic of conversation?
Well,
it was the committee.
It was, but other than just it being a very major news item, that was the extent of it. I didn't discuss it beyond that.
It was a major news item, especially with relationship to the committee, was it not?
Yes, sir. Yes, sir, it was.
Did you find a lot of interest when you were there at the committee, any concerning that incident?
Well, again, Mr. Dash, it was a topic of discussion, but and I know that I did talk about it, but it was nothing more than that.
All right. After that meeting, you returned to California?
Yes, sir, I did.
Now, did you receive a telephone call from Mr. John Dean on June 28?
Yes, I did.
And what did he tell you on the telephone?
As I remember the telephone conversation, Mr. Dean called me. It was in the early afternoon, mid-afternoon on the 28th, and told me that it was a matter of extreme importance that I return to or come back to Washington preferably by the first available flight to undertake a very important assignment.
And what did you do in response to that call?
I took a 10 or 10:15 or 10:30 flight that night.
Arriving when in Washington?
Arriving in Washington at 6:15, 6:30, the following morning.
Now, what did you do next, Mr. Kalmbach?
I then took a cab into town and checked into the Statler Hilton Hotel.
Did you then meet Mr. Dean either at that time or a later time that day?
Yes, after I'd checked in and changed, I think probably I had some breakfast, I called Mr. Dean around, as I can best recall, around 9 o'clock in the morning in his office at the Executive Office Building.
And what transpired? What was the call about? What did Mr. Dean say? What did you say? And what followed?
It seems that in recalling that conversation that I told him that I'm here in Washington at the Statler, and I can come over to your office right now if that's what you wish. He replied that no, you're at the Statler, I'm here at the Executive Office Building. Why don't we both start walking and meet in front of the Hay Adams Hotel? And I said, all right. This had never happened before, but it was a nice day, and I said, all right, I'll do that. I'll meet you in front of the Hay Adams, and then left the hotel. I was there about 9:30, I would guess, and I think I saw him coming up through the park, and I crossed the street, and I suggested that we have coffee at the Hay Adams. He said, no, let's just walk in the park, which we did. We walked for a time, and I recall that he put his foot up on the bench and made some wide gestures and indicating to me that I should do likewise, which I'm not certain that I understood what he meant by that, but I recall that very clearly.
He made wide gestures?
Wide gestures.
And asked you to do likewise?
Well, indicating that perhaps we were being observed, and I don't understand, but I do remember that he did, in fact, do that, and suggest to me that I do likewise.
You certainly would be a greater target of observation if you were both making wide gestures, wouldn't you?
I would think so.
Well, what actually did you and Mr. Dean discuss? What did he say to you, rather than making gestures?
He indicated that the reason for this call and for my coming back to Washington was that it was necessary to talk to me about a very important assignment, namely that he said, he used the editorial "we," said, we would like to have you raise funds for the legal defense of these defendants and for the support of their families.
When you say these defendants, now,
the Watergate...
These were the 7 defendants, Mr. Hunt, Mr. Liddy, Mr. McCord, Mr. Barker, Mr. Sturgis, Mr. Gonzalez.
That is correct.
Now, you knew that they were for all of these defendants.
Well, I just remembered that he said the Watergate defendants at that time, and I wasn't even certain at that point in time that I knew their names.
All right, and did you ask many questions about that?
Yes, I did. I recall that in my conversation with him, I asked whether or not it wouldn't be perhaps preferable to have a public committee formed to raise funds for these people and for these purposes. And also I recall that I wondered aloud about whether or not maybe they could mortgage homes or raise funds in that way until a public committee could be established. His answer to that was that there was no time for this, that a public committee might be misinterpreted, and he just waved it aside and pressed on with this request.
Did he tell you how much money might be involved?
Yeah, my recollection is that he indicated $50,000 to $100,000 for this assignment.
Did he stress, since he had indicated to you that a public effort might be misinterpreted, did he stress that this had to be completely secret?
Yes, he made a very strong point that there was absolute secrecy required, confidentiality, indicating that if this became known, that it might jeopardize the campaign and would, because of misinterpretation as to the reasons for raising these funds and for the help of these people.
Now, who was to give you, since you were to raise these funds, how were you to know how much was to be given to which defendants? Was there a discussion about that?
Yes, sir, there was.
Could you tell us about that?
After he'd made the request, I asked him if when I raised the funds, should I give them to him for distribution? And he said, no, not to me. And he had indicated, I think, Mr. LaRue would be the person...
Is that Mr. Fred LaRue?
Mr. Fred LaRue would be the person who would be giving me directions in this assignment as to specific amounts and specific individuals. And as I can best recall this conversation, I was a little perplexed on this because I didn't know these people at all. And Did
you know Fred LaRue?
Well, I knew, of course, Fred LaRue, but casually. But as to how to distribute these funds. Again, my best recollection is that he indicated at that point that perhaps Mr. Ulasewicz might be the one to act as the distributor for the funds.
Now, is this Tony Ulasewicz?
Yes, sir, it is.
Is that the Tony Ulasewicz that's testified before this committee before?
It is.
Did you know Tony Ulasewicz?
Yes, I did.
Had you worked with him in the past?
I had met with him 2 or 3 times total from mid-1969 until approximately October 1st of 1971, and I had 3 conversations, or 2 or 3 conversations during that period.
Did you have confidence that Mr. Ulasewicz was the kind of person who could be useful in this kind of assignment?
Well, I knew that he had been acting and undertaking assignments for the White House for that period, and I certainly knew that he had the confidence of whoever it was that he was working with. And when he mentioned Mr. Ulasewicz as someone to do this, I said that I certainly would have confidence in him, and
Did you know
I
what
accepted
kind?
that.
Do you know what kind of assignments he had undertaken for the White House before?
No, sir, I did not, Mr. Dash.
But you knew that he would be somebody that they would have confidence in.
Well, I knew that he had been he was a retired New York City police officer who was competent, and I was certain that he was someone that could be trusted, and I'd be glad to work with him.
Who other than Mr. Dean were you thinking of when you say they would have confidence? Do you mean Mr. Haldeman or?
Well, whoever he was talking for. He was using the editorial we all the time.
Well, if he was talking for anybody over at the White House, who did he work with most often, to your knowledge?
Well, Mr. Dean?
Yes.
Well, he worked with practically everyone in the White House, but of course principally
Who above him?
He reported to Mr. Ehrlichman, and he also worked closely with Mr. Haldeman.
Now,
but he did not mention their names in this conversation.
Now, have you ever been given any other assignments of this nature in the past?
No, sir.
Now, after meeting with Mr. Dean, what did you do? Did you indicate first that you would accept this assignment for Mr. Dean?
I did.
And you did accept it on the basis that if Mr. Dean was asking you, as the President's counsel, that he had authority to ask you for that?
Absolutely. I had known Mr. Dean since mid-1970, and I had complete trust in the man, and knowing that he was the counsel to the President.
All right, then you accepted this assignment. What did you do right after that meeting with Mr. Dean?
I walked back to the Statler Hilton, and I think within a matter of minutes after I was back at the hotel, I called Mr. Stans.
And what did you say to Mr. Stans?
I told him that I had been given a special assignment requiring as much cash as perhaps he would have available. I think I mentioned $50,000 to $100,000, and asked him if it would be possible that he could help me in this assignment.
And what did he say?
He said that he would see what he could do. He said that he would have, as I remember it, he said he would have to go to a safe deposit box, but that he would meet me at the Statler Hilton in my room early in the afternoon.
And did he meet you early in the afternoon?
Yes, sir, he did.
And did he have anything with him?
Yes, he did. He gave me $75,100.
How were they packaged?
It was in $100 bills, as I remember it.
And did he indicate to you the source of that money, Mr. Kalmbach?
He did. As to $45,000, he said that it was the balance of the $50,000 that he had earlier given me. He said that he was giving it to me now, but he did not indicate, as I remember at all, the source of the balance of those funds.
Now, did you tell Mr. Stans at any time when you asked for this money and when you received it, what that money was going to be used for?
No, I did not.
Did Mr. Stans question you as to why you needed the money?
Again, Mr. Dash, when I talked to Mr. Stans, we'd known each other a number of years. I told him it was for a very important assignment, that I had been advised that it was in complete confidence, that I could not tell him the nature of the assignment, that he would have to trust me. And he said, of course, I do trust you, Herb. And with that, he gave me the funds.
All right, now what did you do with the money that Stans gave you?
I held the funds until the following day when I gave them to Mr. Ulasewicz.
How did you make contact with Mr. Ulasewicz?
When I had met with Mr. Dean, I recall that it seems to me that I asked him to get in touch with Mr. Caulfield who he knew well and who knew Mr. Ulaswitz's number in New York, and to ask Mr. Caulfield to call me and give me that number, and then I would call Mr. Ulaswitz, and that is what I recall that I did. I received the call and then called Mr. Ulaswitz late in the afternoon on the, let's see, it was the 29th, and asking him to come down to Washington the next day on the 30th.
Did you say anything on the telephone as to why he should come down? Just told him?
No, I just said that I wanted to see him for a special assignment.
And then you had a meeting with him?
Yes, I did.
And where did you meet with him?
I met with him in my room at the Statler Hilton Hotel.
And did you tell then Mr. Ulaswitz or ask him to undertake this assignment?
Yes, sir, I did. I told him exactly what Mr. Dean had told me, namely that the purpose of this assignment was to provide funds for these defendants for their legal help, and also to provide support for their families. And I stressed again the statement that Mr. Dean had given to me that it must be in absolute secrecy and confidentiality, and he thoroughly understood and took the funds and left and went back to New York.
Right, so he agreed to follow out this assignment,
yes,
as you had requested. Now, prior to Mr. Ulaswitz coming down, did you again meet with Mr. Dean?
Yes, I met with him on Friday morning. Yeah. On Friday morning, at which time I told him that I had contacted Mr. Ulaswitz, that Mr. Ulaswitz would be in Washington that afternoon, and that I had raised $75,100.
Where was that meeting?
In my room at the Statler.
Could it have been, Mr. Kalmbach, that you first had coffee in the coffee shop with Mr. This was at Statler Hilton?
Yes, sir, it was.
Yeah. Could you first met at the coffee shop and then at your room?
Well, I could have been, but my recollection is that we met in my room.
Right. Now, you've testified that when you met with Mr. Ulaswitz, you stressed the secrecy that Mr. Dean had stressed with you. Did you arrive at any method with Mr. Ulaswitz as how you would carry out this assignment under a covert operation?
Well, the method was that it was again stressed absolute secrecy. In my conversations with Mr. Ulaswitz, when I stressed that, in our talks between ourselves, it was agreed that we should use telephone booths, talk between telephone booths, and of course, as it later became procedure, that in his conversations with various of these people to whom he was contacting, he would use an alias. That,
Mr. Ulaswitz would use an alias?
Yes, he would.
Did you know what Mr. Ulaswitz's alias was during this transaction?
No, I think there were several.
There's the name Rivers?
I think that was one of them. Yes, sir.
You know, did he suggest that name?
Well, I don't know if he did or whether I did, but in our conversation, but then I would then report to either Mr. Dean or Mr. LaRue, who would give us the directions, or give me the directions. I would then give Mr. Ulaswitz the directions. He would then make the contact with the...
right, and those directions you would give to Mr. Ulaswitz would be on the telephone, would they not?
Yes, sir.
And they would be from telephone booth to telephone booth. Could you just give us
Usually.
All right, could you just give us a kind of scenario how you would contact Mr. Ulaswitz or he would contact you, what one would say to the other, and then how would you do it?
Well, if there is a typical, I don't know if there is, but I would receive a call either from Mr. Dean or Mr. LaRue with instructions to get X amount of funds over to one of the defendants or one of the attorneys. I would then call Mr. Ulaswitz and so inform him.
Now you would call him and reach him at his home number?
I would reach him in New York at his home number.
And then what would you tell him to do?
I would call him from a payphone he would then he told me the number of another payphone, and 15 minutes later I would call him and he would be at the payphone.
Now, when you called him, did you use a telephone credit card?
No, always in the, it was in cash, and that was using a good number of quarters.
There's kind of a lot of quarters in the
Yes,
telephone
sir.
as you went along. And when you referred to a particular people who would receive it, take Mr. Hunt, did you have a particular code name for Mr. Hunt?
I think we did. I think we called Mr. Hunt, just called him the writer. He'd been an author. We just called him the writer. And I think we called Mrs. Hunt the writer's wife. I don't recall that we had any other names for anyone else.
Did you have any particular code name for the money that actually was being distributed?
No, if there is a code name, the name developed in when I was at the Statler and Mr. Ulasewicz came down to receive the $75,100 that I'd received from Mr. Stans. He came into the room and he didn't have a briefcase with him, so he just went to the shelf in the room and wrapped it in a laundry bag. And so after that, we both called it the laundry as to how much money you had available.
And he carried
that was just and he carried it back in that laundry bag, as I remember it.
Kind of a significant name at this time to be used for
Yes,
that money,
it
was
is.
it not? Did you ever use the term script with such a conversation?
I think we had that term script.
Script for the writer, script for the writer.
Meaning the script of all of the players involved, the defendants and certain of these attorneys that were representing certain of the defendants.
Now, did Mr. Ulasewicz have any knowledge or reason to know about these activities? He knew what you knew, did he not?
Yes, sir.
Did you discuss with him at all the propriety of this activity?
No, sir. I told him that it was proper, and I told him that the purpose, as I've stated, was to furnish legal help for these people and to furnish them with family support.
Now, you did know, of course, that the particular people who were getting this money for their legal defense or support of families were charged or indicted with under the crime of burglary and illegal wiretapping and conspiracy, did you not?
I knew the essence of the charges, yes, sir.
Right. And other than being told by Mr. Dean that this would be an appropriate thing to do, you made no independent inquiry as to the propriety of this?
No, I made none.
Now, how were instructions about the distribution of funds given to you and Mr. Ulasewicz? Was that by phone from LaRue to Dean or Dean?
Probably 90% of the time it was by telephone. The other 10% was in personal discussion with him in his office, or more usually in Mr. Dean's office.
Now, what was the first instruction you received to give money?
Again, as I've tried to reconstruct this, Mr. Dash, the first instruction that I received, which I passed to Mr. Ulasewicz, was to have Mr. Ulasewicz give $25,000 to Mr. Caddy in a, I don't know Mr. Caddy. I understand he's an attorney here in Washington. Again, as I recall it, this was probably from approximately July 1st through to July 6th or 7th. There were a number of calls. I would talk to either Mr. Dean or Mr. LaRue. I would then call Mr. Ulasewicz, who in turn would call Mr. Caddy. He would have some response from Mr. Caddy that I would call back up to either Mr. Dean and Mr. LaRue.
What was the response? Was Mr. Caddy...
Well, there was the sum and the gist of it was that Mr. Caddy refused to accept the funds.
In that manner?
That's correct. That was the end all. There were several telephone calls, but the final wrap-up on it was that he refused to receive the funds.
And who was contacted next? Which lawyer?
I think Mr. O'Brien was contacted, and again with the same result.
He refused to receive the funds?
Yes, sir.
And then who next was approached?
I think then it was Mr. Bittman And Mr. Bittman, and I think this may have been when the name Rivers was used, Mr. Dash, but my recollection would be that Mr. Bittman received $25,000 probably sometime during the second week of July of 1972.
And that you followed an unusual procedure that when Mr. Ulasewicz would make the contact and then and pay the money, he would call you, and then you would call Mr. Dean and tell him it had been accomplished?
Or Mr. LaRue, yes.
Or Mr. LaRue. And were these phone calls by telephone booth?
Yes, sir.
Even when you spoke to Mr. Dean?
Yes, that's
or
correct.
Mr. LaRue?
That's correct.
What other lawyers were supposed to receive money, to your recollection, Mr. Kalmbach?
Well, after the dispersal to Mr. Bittman, I think there was most of the remaining funds went to Mrs. Hunt, who in fact was the person who did the distributing thereafter, and she distributed to these other attorneys.
Mrs. Hunt?
Yes.
Now, when did you next return to Washington after this first series of meetings where you received this money, met with Mr. Ulasewicz? When did you next return to Washington?
Well, the next time that I was back in Washington involved in this assignment, Mr. Dash, was I think it was on July 19th.
And what happened at that time?
At that time,
what brought you back?
Well, I think I was asked to come back, I think by either Mr. Dean or Mr. LaRue, and to meet with Mr. Dean and Mr. LaRue in Mr. Dean's office in the Executive Office Building.
And did you receive any money from Mr. LaRue at that time?
Yes, sir, I did.
How much was that?
Oh, some $40,000 was received from Mr. LaRue at that time.
And where did you receive it?
In Mr. Dean's office.
Did you receive any additional instructions at that time?
I may have, Mr. Dash. I'm not certain as to that.
And what did you do with this money, this $40,000? Was this in cash, by the way?
Yes, it was in cash.
And you know the denominations of the cash?
I think it was primarily $100 bills.
All right, what did you do with this new supply of money?
I took these funds and I think I went to New York late that afternoon, stayed at the Regency Hotel, and gave the funds to Mr. Ulasewicz, who came to my room in the Regency, probably around 8:30 or 9 that evening.
Now, you returned the following week, did you not, Mr. Kalmbach, to Washington?
Yes, sir, I did.
Now, why did you return? When did you return? Who did you see?
About this time, Mr. Dash, I was being urged to recall from my testimony that the funds that were given to me by Mr. LaRue were not solicited by me. They were simply given to me to be given to Mr. Ulasewicz. About this time, I was asked by either Mr. Dean or Mr. LaRue to raise additional funds, and I began to have a degree of concern about this assignment.
What began to cause you to have that degree of concern? Was it the nature of the covert operations? Was it the fact that you were paying this money to defendants? Could you give a little description or basis or background of that concern?
I think the primary reason for my concern was the secrecy and the clandestine covert nature of this activity.
Sort of like a 007 operation.
It was a James Bond scenario.
And you were part of that whole scenario?
Yes, sir.
The President's personal attorney.
And it was very distasteful to me, and it had created this degree of concern, and the concern was sufficient to make me certain in my own mind that I wanted to talk to John Ehrlichman.
Why?
And I wanted John Ehrlichman to confirm that John Dean did in fact have the authority to direct me to undertake this assignment. Second, that I wanted him to assure me as to the propriety of this assignment. In any event, I requested a meeting with John Ehrlichman, My records indicate that I met with him in his office at 3:30 on July 26th.
Could you describe that meeting for us, what
Yes,
you
sir.
said to him and what he said to you?
Yes, sir. As I've stated, the reason for the meeting was to get the assurance as to Mr. Dean's authority and as to the propriety.
Also, at this time, you were being asked to go out and raise some additional funds on your own, were you not, Mr. Kalmbach?
Yes, sir, and this would be the first time, Mr. Dash, that I would be going to an outside contributor. I know that the secrecy involved in this was, as I say, very distasteful. It was probably the primary item of concern, feeding this concern that I had. Other factors would include the fact that, Mr. Haldeman, Mr. Ehrlichman, back around April 7th had indicated to me that I had been involved in this fundraising activity for such a long period that
Go and vote, just vote on the Senate. Back as soon as possible.
Once again, a floor vote has interrupted the proceedings, so we'll also take a short break. Public television's coverage of the Senate Watergate hearings will continue after a pause for station identification.
Unabridged coverage of these hearings is provided as a public service by the member stations of PBS, the Public Broadcasting Service. From Washington, NPACT continues its coverage of hearings by the Senate Select Committee on Presidential Campaign Activities. Here again, correspondent Jim Lehrer.
As the senators return to the hearing room, Majority Counsel Sam Dash is asking Herbert Kalmbach about getting John Ehrlichman's okay to raise money for the Watergate defendants.
Mr. Kalmbach, would you please take this? Mr. Kalmbach, we were just at the point where you had come into Washington on the 26th to see Mr. Ehrlichman because, as you've testified, you had developed a real concern based on the secrecy of the activity of working with Mr. Ulasewicz and the delivery of the money, and the fact that you are now being asked to go out and raise new funds, and you wanted to see Mr. Ehrlichman in order to find out, one, whether or not Mr. Dean had the authority to ask you to do this, and I think, two, whether or not it was proper. And could you then take it on from there, Mr. Kalmbach?
Yes, sir.
I think I asked you, what did you say to Mr. Ehrlichman, and what did he say to you?
Well, when I first went into that meeting with Mr. Ehrlichman, I told him, "You're familiar with this assignment?" He says, "Yes, I am." And
would you say that again? What did you ask him?
I said, "You're familiar with this assignment that I have received from John Dean?" He said, "Yes, I am."
By that assignment, you meant the payment of the money.
That's correct.
And you were sure that he understood what you were talking about?
Absolutely. And I went through it as far as the secrecy and how this secrecy was bothering me, indicating to him that this is something that was new and foreign to me. I told him that the press was giving me concern. The whole secrecy thing, the press, this and that.
What do you mean, the press?
Well, I mean, the press coverage on the Watergate. I was beginning to have concern about this assignment, and I said that, John, I want you to tell me, and I can remember it very vividly because I looked at him and I said, "John, I'm looking right into your eyes." I said, "I know Gene and your family. You know Barbara and my family. You know that my family and my reputation mean everything to me. And it's just absolutely necessary, John, that you tell me, first, that John Dean has the authority to direct me in this assignment, that it's a proper assignment, and that I'm to go forward on it."
And did he look at you in the eyes?
Yes, he did. And
what did he say to you?
He said, "Herb, John Dean does have the authority. It is proper, and you are to go forward." Now, he said, in commenting on the secrecy, he explained that as saying that but for the secrecy, this whole assignment, getting these funds to these people for this purpose, could get into the press and be misinterpreted. And then I remember he used the figure speech. He said they would have our heads in their laps, which again would indicate to me that it would jeopardize the campaign.
Did he say something like this was political dynamite?
Well, I don't remember that, but I remember the heads in their laps remark. He might have said political dynamite, but the effect of all of this, Mr. Dash, was to
reassure you.
The effect actually was that it washed out the concern that I'd had, that had built up preliminary to this meeting, and I went out of that meeting certain that it was proper for me to go back to California and approach this contributor, this first contributor that I would approach in this program.
Well, even though he told you then that you had to maintain the secrecy, and that if it ever got out, they and I take it they may have meant the Democrats,
yes,
would have our heads in their laps and might jeopardize the campaign. that didn't suggest you in the impropriety in your doing that?
No, it did not.
Why not?
It just it suggested to me that the concern was that that this would have a, if it got into the press, misinterpreted, it would have.
How could it be misinterpreted?
It would misinterpret it in whatever way that funds were being given to these people.
Well, now how could your providing funds through either Mr. Dean's aegis or Mr. Ehrlichman's aegis through the committee to burglars, wiretappers, and conspirators be misinterpreted?
Well, the misinterpretation would be that this was being done to silence these people.
Could anybody have any other interpretation?
I did.
What interpretation did you have, Mr. Kalmbach?
I had the interpretation, as I stated in my opening statement, that I felt that the green light had been given to these people in some manner, expressly or implicitly, and maybe by just by chance, where they had gone forward on this idiotic and stupid thing into in this Watergate break-in, an illegal act, and that someone, and I did not know who, and I never knew to whom Mr. Dean and Mr. LaRue reported. I just had the feeling that someone had given the go-ahead in some manner, and that someone felt that even though these people have done an illegal act, the decent thing to do is to provide them with, at least provide them with lawyers and provide them with family support.
And not to see that certain people were fired and to come out and disclaim it, rather than actually support these people who were charged with any offense.
Mr. Dash, I had no background knowledge at all, and this is just the impression that I received, and I thought, frankly, it was again a very human thing.
Well, in a real sense, you took your so-called moral standard from Mr. Ehrlichman's statement. It was appropriate.
Well, Mr. Dash, I think it's more, I have had such trust in Mr. Dean and Mr. Ehrlichman that if I was advised by them, assured by them, there was, in my mind, there was no possibility there'd be any
impropriety.
Any impropriety, no, sir.
All right, now, at that time when you've been reassured by Mr. Ehrlichman, did you pick up any additional money from Mr. LaRue while you were in Washington?
Yes, I recall that I think I picked up approximately $30,000 the next day that Mr. LaRue gave to me in his office at 1701 Pennsylvania.
And did you have any additional instructions with regard to that money?
I may have, Mr. Dash, I don't recall.
Now, what did you do with that money?
I called Mr. Ulasewicz, who came down to Washington and stayed at the Statler Hilton, and I gave him those funds in his room at the Statler Hilton.
All right, now you then returned to California, did you not?
Yes, sir.
Did you raise that additional amount of money that you were asked to raise?
Yes, I did. I called Mr. Thomas V. Jones sometime between, I think it was August 1st and August 5th, I'm not certain as to the date, and indicated that I would like to come by and see him. He had earlier indicated to me that he would have funds for me if there was any special need.
Now, that he was his reference, who, by the way, since you named him, who is Mr. Jones?
He is chairman of Northrop Corporation in California.
And has he been a political contributor to Mr. Nixon, the president?
Yes, sir, he has, personally.
And when he indicated to you that earlier that if you needed any help that he would provide those funds, was that in the area of contributing to the president's re-election campaign?
Yes, sir.
All right, now you called him and told him what?
I called him, and I think I reminded him on the telephone of his earlier statement to me, and he indicated immediately that he'd be glad to see me, and we worked out a time that was mutually convenient. I went to his office in Century City in West Los Angeles. I think it was in mid-afternoon, and met with him there, and we had a 15-minute meeting or thereabouts, and he took from his desk a package and handed it to me. I put it in my briefcase and left his office and went back to Newport Beach.
What was in the packet?
It was $75,000 in cash.
And do you know what denominations the money was in?
$100 bills, as I remember it.
Now, when you spoke to Mr. Jones, did you tell him why you wanted the money?
No, again, just as with Mr. Stans, I told him that it was for a special assignment. I told him it was an assignment that I could not reveal the nature of it, that I'd been given the assignment by someone in authority at the White House, and that was sufficient.
Would it be fair to say that he would have assumed that it had something to do with the campaign for the re-election of the president?
I think it would be, yes, sir.
And as a matter of fact, it did not, did it?
Well, it was for the purpose that I've stated.
Yes. Now, what did you do with these funds? Did you give them to Mr. Ulasewicz?
Within, I think it was the next day or possibly the day following, Mr. Ulasewicz came out to California at my request, and I met him in Orange County in front of the Airport Inn in Orange County, near my office in Newport Beach.
And could you describe how you gave him the funds there?
Yes, sir. I asked him to meet me in front of the Airport Inn. I drove over in my car, picked him up. We drove and parked and talked. I gave him the funds. I think we probably reviewed our own notes as to how much had been received and how much had been distributed and to whom. And then after, I think it was a half hour or so, I let him out in front of the Orange County Airport.
So again, this method of transmission of the funds was in a sort of a covert, secret method. You did it,
yes, sir,
in the automobile, out on the road,
absolutely,
and transferred it to him in the original packet.
Yes, in the original packet, I'm certain.
And and then he flew. Did he fly back to New York with that?
Presumably that night, although I'm not certain of that.
Now, did you ever discuss that $75,000 that you raised from Mr. Jones with anyone?
Well, my memory is that within a few days after that, I was in Washington, and I think I saw Mr. Ehrlichman at that time, and I told him of the fact that I had raised $75,000 from Mr. Jones for that assignment. That's my recollection of at the time I met with Mr. Ehrlichman. I think there were other things we discussed, but
what was Mr. Ehrlichman's reaction when you told him that you had raised that money?
It was just fine, without more.
No, you were following out the original reassurance, and you knew you were doing the job.
Yes, sir.
While you're on that same trip to Washington, your calendar shows at 8 a.m. a meeting with John Connolly on August the 8th. You know, was that in relationship to this in any way?
In no way whatsoever.
Did you discuss your activities with him at that time?
As to this assignment?
Yes.
Absolutely not.
Now, when did you decide to stop raising any money for the defendants and their attorneys?
Well, Mr. Dash, probably in mid-August, and then continuing, it's my recollection that Mr. Dean and Mr. LaRue contacted me and indicating they needed additional funds. And by this time, in late August, this whole degree of concern had come back on me. It had come back on me to the level that I knew that I did not want to participate any longer in this assignment.
Well, was Mr. Ehrlichman's reassurance enduring?
No, it was not.
What was the concern, again, the covert activity, the secrecy of it?
I think that was the primary factor, Mr. Dash. I think that Mr. Ulasewicz mentioned some cautionary words that from a professional police officer gave me some pause. I think there were other things, again, the press, but...
You mean the newspaper stories about Watergate and was coming more and more to the fore, were they not?
Yes, sir. And I think that just all of it together was enough, so that certainly by, as I say, late August, September, I was certain that I would not continue in this assignment.
Did you discuss this with Mr. Ehrlichman?
No, sir, I did not.
Your calendar shows an 8:15 a.m. breakfast with Mr. Ehrlichman on August 29th, which was about the time you were making this decision. Did you discuss it with him at that breakfast?
No, I did not. I don't recall, Mr. Dash, that I ever discussed this with Mr. Ehrlichman after making that decision.
Well, did you tell John Dean anything?
Well, I just simply told him that I would do no more. And I advised Mr. LaRue, too, that I could do no more.
Now, during the months of July and August, were you in frequent contact with Mr. LaRue to receive instructions for distributing these funds?
I think during that time that my contacts, again, I don't remember whether they were Mr. LaRue or Mr. Dean. They're interchangeable in a sense. But there were instructions to disperse the funds right up till, I think the last instruction that I received was in, again, my memory tells me it's the 17th, 18th of September.
Was that instruction to distribute the remainder of the funds immediately?
Yes, I think the words were an immediate, there was the direction was for me to have the funds dispersed immediately to Mrs. Hunt, and then the balance of the funds to Mr. LaRue, which was the first time that I can recall that Mr. LaRue received funds.
All right, and did you request a reconciliation of your cash records with LaRue and the last one that you distributed?
Yeah, yes, I did.
Could you tell us about the meeting in which that reconciliation took place?
Well, again, my memory is that the reconciliation was probably on the 21st of September.
And who was there? Where was it taken? Where did it take place?
I think it took place in Mr. Dean's office, and I think that Mr. LaRue was present. And I was that's my recollection as to the date. And at that time, I just went through my entire record that I had in my notes, indicating the total funds received, total dispersed, and those in that income and outgo agreed with Mr. LaRue's records and Mr.
Do you recall
Dean's
what that
records.
total amount was?
I beg your pardon?
Do you recall what that total amount was?
I think it was approximately $220,000.
What happened to what did you do with your notes with the termination?
I then destroyed the notes.
Where?
In his office, in Mr. Dean's office.
How were they destroyed?
Well, my recollection is that I asked him to shred my notes, and he was smoking, and I'm not sure who used matches, but the notes were destroyed.
Were you ever again, Mr. Kalmbach, asked to raise money for the defendants after you broke off, decided in September that you wouldn't do it anymore for the concerns that you've expressed? Were you ever again requested to do the same thing?
Yes, I was.
Could you tell us when you can recall that happening and who was there?
I think I may have been approached once or twice after the September 21st meeting, but I remember with great particularity a meeting that occurred on the 19th of January in Washington, Mr. Mitchell's office.
And who was there with Mr. Mitchell?
It was Mr. Mitchell, Mr. Dean, Mr. LaRue, and myself.
And could you please tell us very briefly what the discussion was, who said what you said?
I had been asked by Mr. Dean at a meeting it was held just minutes before at Blair House that Mr. Mitchell wanted to see me in his office. And I recall that it was a rainy afternoon, and we ran through the rain a half block to 1701 Pennsylvania, went up to Mr. Mitchell's office, and when we walked into his office, we joined Mr. Mitchell, who was seated at his desk, and Mr. LaRue, who was also in the office. After we were seated and after the opening amenities, I think it was Mr. Dean that led the conversation, and immediately I could see that the purpose of this meeting was to ask me to raise additional funds. And immediately, as soon as that became known, Mr. Dean said the need for raising additional funds for lawyers and for family support. I knew I wanted to withdraw as soon as possible, and I excused myself within I think 10 minutes at the most, 10 or 15 minutes at
Now,
the most.
Mr. Mitchell was present. He was in his office.
Yes, sir, he was.
Did he participate in the discussion?
Well, I remember he was smoking his pipe. I was aware of the conversation. We were all seated right around his desk. But it's my recollection that Mr. Dean led the conversation, and I don't remember, Mr. Dash, what comments Mr. Mitchell or Mr. LaRue added to the conversation.
Or in any event, you turned them down.
Yes, sir, I did.
And that was the end of your fundraising for the defendants in the Watergate case.
Yes, sir.
I have no further questions, Mr. Chairman. Well, that again, I think for the record, that was January the 19th, was it not?
Yes, sir, it was.
Right, 1973.
Yes, sir.
Right, I have no further questions, Mr. Chairman.
Fred, you want to start? Yes, sir, I should be brief.
Mr. Kalmbach, you state that the immediate reason why you became involved in the fundraising was a telephone call which you received from John Dean on June the 28th. Is that correct?
Yes, sir, it is.
For that reason, I'd like to compare some of your testimony with that of Mr. Dean and see whether or not your recollection is correct. First of all, you state that you checked in the Statler Hilton Hotel. Is that correct, when you
Yes.
arrived here on the 29th?
Yes, sir.
I believe Mr. Dean says that he met you in the Mayflower Hotel. Could you be mistaken?
No, I don't think I'm mistaken. I think Mr. Dean may be mistaken on that.
He states that a few days later you met in Lafayette Park and talked to him. Did you meet with him a few days after the 29th in Lafayette Park?
No, my recollection, Mr. Thompson, is that I met him on the morning of the 29th in Lafayette Park, as I've testified. And
You think there's a confusion of running two meetings into one or something to that effect, perhaps, in his mind?
no, I don't know, Mr. Thompson, what his recollection is. I know what Mr. Dean has testified to. We just have a different memory on this. My memory is that we met in the park that morning on the 29th and then met at the Statler Hilton on the 30th.
In this conversation, I believe he said something to the effect that he told you everything, and he told you that Holloman, Ehrlichman, Mitchell were interested in your raising this money. Is that correct?
No, I don't have any recollection of him mentioning any of those people.
You think he would remember it?
He was the editorial we.
Are you saying he didn't say it, or that you don't have any recollection of his saying it?
I don't recall that he said it.
He also stated that you suggested the use of Tony Ulasewicz. Is that correct?
No.
Who suggested the use of Tony
Again,
Ulasewicz?
I've stated that my memory of that meeting is that I first indicated to him that I would give him the funds, and then if not Mr. Dean, I would give the funds to Mr. LaRue. And it was at that point, not knowing who was going to receive the funds, that my recollection is that he suggested Mr. Ulasewicz, which I agreed with, and as I had trust in Mr. Ulasewicz.
Did you know Ulasewicz before the 29th of June?
No, only I think I had met him 2 or 3 times in total during the period from mid-'69 until approximately October 1st of '71, and only
What did you understand his function was, or assignments were, during that period of time?
My understanding is that he was doing investigative work for the White House. I wasn't certain as to the nature of the assignments other than just investigative work.
But in the first week of July, did you receive a telephone call from John Dean when he indicated that Attorney Caddy was to get a certain amount of money and Hunt was to get a certain amount of money, and perhaps other people?
Yes, sir. I remember receiving a call, and I'm not certain, Mr. Thompson, whether it was Mr. Dean or Mr. LaRue instructing me that Mr. Caddy was to be given these funds.
All right. Let me ask you about the meeting on July 19, which you had in Mr. Dean's office. If I remember Mr. Dean's testimony correctly about this, or his prepared statement on this, he said the purpose of that meeting was for you to determine in your own mind exactly who the payments were supposed to be made to. He didn't talk about the passing of any money in his presence. Can you tell us the purpose of that meeting?
No, there was again, my recollection of that meeting was that some $40,000 was given to me by Mr. LaRue in Mr. Dean's office. And there may well have been instructions given to me at that time.
But there's no question about the passing of money on that occasion?
No, that is no question.
Was that in Mr. Dean's presence?
That is, as I remembered, the three of us were together in his office at that time.
Do you recall whether or not he was on and off the telephone during that period of time?
Well, I think he probably had some calls, but the three of us were together in that meeting.
Facing each other?
I think Mr. Dean was at his desk, and Mr. LaRue and I were seated together at his desk.
Well, in mid-September, did you receive a telephone call telling you to tell Tony Ulasewicz to give Mr. LaRue $30,000, I believe in the Howard Johnson's across from the Watergate, ironically enough?
Yes, the instruction was to give Mr. LaRue the $30,000. I'm not certain in my memory whether I was told how it was to be handed to him.
Well, first of all, let me ask you, who told you to do this?
Again, it was either Mr. Dean or Mr. LaRue. I think
well, if the money was going to LaRue, it looks like you could determine in your own mind whether LaRue was saying give it to me or whether or not Dean was saying give it to LaRue.
Well, I think, Mr. Thompson, this particular conversation was with Mr. Dean, and it was to give these funds to Mr. LaRue. And I think, again, my recollection is that I asked Mr. Ulasewicz to call Mr. LaRue at his apartment in the Watergate Hotel.
All right. The reason I ask this is because I don't believe Mr. Dean mentioned that particular telephone conversation or any conversations concerning his asking you to deliver certain amounts of money or the passing of any money in his presence.
Yes,
Were
well,
you?
I wanted to make it clear that it was interchangeable as far as I was concerned between Mr. Dean and Mr. LaRue on these instructions. That whereas Mr. Dean had told me that Mr. LaRue would give me instructions, I recall that oftentimes Mr. Dean would talk to me about instructions and who was to receive what.
Was anyone instrumental in pushing you to continue to raise money, either Mr. Dean or LaRue or anyone else?
No, I think that Mr. Dean was probably the one that talked to me most often about this to continue in this program. And it seemed to me that Mr. LaRue might have spoken to me once or twice, but I don't recall that.
You believe you had more conversations with the Dean than you did LaRue about these matters?
As far as being urged to raise additional funds, yes, sir.
All right. Thank you, Mr. Kalmbach. I have no further questions, Mr. Chairman.
The committee will stand in recess till 10 o'clock tomorrow.
So, the day ended with the pressure up still a bit more to get the documents the committee wants from the White House. With a flair that would have made a playwright proud, the committee followed the generally mild testimony of Richard Moore with that of Federal Aviation Administrator Alexander Butterfield, who told how the President's office meetings and telephone conversations were taped. The White House admits the truth of Butterfield's testimony and says the President is aware of his remarks.
All of us are suddenly faced with the possibility of being able to listen to a group of tape recordings that could resolve once and for all the basic question of President Nixon's possible involvement in and knowledge of the Watergate cover-up. Well, two gentlemen watched today's session with us today and heard these revelations along with everyone else, and they are Bob Kodesh, Washington attorney, author of the new book, The Institutional Imperative, and David Epstein, adjunct professor of law at the Georgetown University Law Center in Washington. And I'll ask you the very simple question, gentlemen, have I overstated what we learned today? What do you think, Mr. Epstein?
This is of critical importance, and one of the rules of law that hasn't been mentioned too much by the senators is the best evidence rule. The point is that the best evidence of what went on in these conversations that John Dean testified to is the tapes. Either John Dean's conversations took place with the President as John Dean testified, or something else was said during these conversations, and these tapes will be the ones that can lead us to an understanding of what happened there. It's interesting that Mr. Butterfield said that one of the reasons for keeping these tapes was for historical record. Now, what could be more important than these historic hearings that are taking place? And the way of making the historical record clear at this time is to make these tapes available and let the committee and the public find out what actually happened during these various meetings.
Bob, what do you make of all this?
Well, I think what you said is true, that certainly it's pretty vital evidence that's going to come out. What fascinated me was the way the White House staff was organized. These revelations are just fascinating as you see the intricacies of the organization and you see how everybody was running on his own little set of rails and attending to his own duties. I believe Mr. Butterfield said that only 4 people, maybe 5, including his secretary, knew what was going on with the tape recording, except that it was being recorded and the depository was with the Secret Service.
David, what do you think of the whether executive privilege could be invoked realistically to withhold these tape recordings from the committee?
Well, I think at this point the committee is relying quite a lot on public pressure. Time and again, Senator Baker and Senator Ervin state the rule of law that if a witness has evidence or information that's peculiarly within his capability and his possession and he doesn't come forward with that information, then you can draw an adverse inference. Then you can presume that if the information were made public by that witness who has it, that it would be contrary to the witness's interests. So it's not really at this point a question of executive privilege, but a question of presenting to the public the fact that the President has certain tapes concerning conversations that he had, and up to this point he hasn't made them available. Now, Mr. Butterfield suggested that the President was going to base his defense on them, and the question then is, why has the President waited up till now before making known the existence of these tapes?
Bob, do you see any realistic way that the President could withhold these tapes at this stage of the game? I mean, above and beyond the legal side, above and beyond executive privilege, I mean, public pressure, don't you think it'll force him to some way make these tapes available?
Remember a famous statement of Jefferson, wasn't it? It said, John Marshall has made his decision, now let him enforce it. Speaking of our famous first Supreme Court Chief Justice. The President has an awful lot of practical power, and there's an awful lot in those tapes. There are a lot of conversations recorded that probably, for many reasons, he wouldn't want out. No one would. You wouldn't want the conversations in your own living room recorded and coming out. Practically, he can say no, can't he?
Sure, and that also poses another very interesting question. In order to find the portions on the tape that would be relevant to this inquiry, somebody's going to have to sit and listen to all of them. And you made a good point. Who would that person be? 2 guys from the committee? What 2 guys? What kind of bounds would they be under? It could present some very difficult problems.
There's some court procedures that have been developed for confidential information where the judge takes the information and goes through it in chambers.
Yeah.
And then the judge decides whether it is relevant and it can be released. That's been attacked in a number of cases involving ordinary lawsuits as not giving the defense or the plaintiff or the defendant the chance to know what's and argue with the judge about it, but it has been done.
Of course, presumably the reason for having taped the conversations in the President's own living room, so to speak, was that at some point they would be made available. Of course, the President, I presume, thought that they would be made available under the circumstances and at a time of his own choosing. The hearings have changed the timing of that, and now I think you're quite right in pointing out the pressure is enormous for having them revealed at this time.
And also, you're quite right in pointing out that regardless of whether we ever hear the tapes or in what conditions, that these tape recordings have now become historically the most historically famous tape recordings in the history of the United States government. Thank you both very much.
The discovery of the presidential tapes today may, in the short run, raise more questions than are answered, especially over the committee's ability to get access to them. NPAC's Peter Kay talked today with Chief Committee Counsel Sam Dash about that problem.
Mr. Dash, do you seriously think that a White House that's reluctant to turn over staff documents is going to make tape recordings of presidential conversations available to this committee?
I think the issue can be more properly put, that we're not dealing here with so-called papers that the President has identified as executive privilege, no matter how much we may differ on the issue of executive privilege. Here we're talking about specific conversations with Mr. Dean that even the President has indicated there's been no executive privilege, where he has waived attorney-client privilege and executive privilege issues and has already given us substantial information concerning that. It would seem to me it's quite late in the day for anybody to be withholding that information. That's quite different than rummaging through his papers. We have specific dates now. We have specific information given. We now can ask for that specific information.
No national security either.
No national security involved here.
The disclosure of the existence of the White House tapes is not only the most dramatic thing to come out of the hearings so far, it completely alters the situation regarding what the committee sees as its most burning point of inquiry. In Senator Baker's definition, it is what the President knew and when he knew it. Until today, John Dean looked very isolated as the President's accuser. It was unlikely that anyone coming up in the witness list would have either the motivation or the knowledge to corroborate what Dean claimed, that President Nixon knew of the cover-up for 8 months. Conversely, even after a parade of Nixon loyalists, including Haldeman, Ehrlichman, Colson, claiming that the President did not know, the nation might have remained as skeptical as the Gallup and other polls currently show it is. The tapes can change all that decisively and completely. If the White House agrees to release them, they will show that John Dean is right or that Mr. Nixon is right. The decisive date may be the conversation of March 13th this year, when Dean claims he discussed both hush money and executive clemency with the President. If the actual Dean-Nixon conversations are not conclusive, there are any number of other conversations or telephone calls with Colson, Mitchell, Haldeman, and Ehrlichman which could exonerate or incriminate the President, all meticulously recorded in this passion for posterity. What remains is this question: will Mr. Nixon release the tapes? It's hard to conceive of him refusing to do so. The nation knows that John Dean has accused the President of conniving in a massive obstruction of justice. The nation now knows the truth resides not in people's hazy or biased memories, but on magnetic tape. Not to release the tapes, or to announce that they had been accidentally erased or destroyed, would leave the gravest suspicions in the already skeptical public mind. Well, we'll be back tomorrow night at the same time. On behalf of my colleagues, Peter Kay and Jim Lehrer, this is Robert McNeil. Good night for NPACT.
From Washington, you've been watching gavel-to-gavel videotape coverage of hearings by the Senate Select Committee on Presidential Campaign Activities. This coverage is made possible by grants for special events coverage from the Corporation for Public Broadcasting and the Ford Foundation, and has been a production of NPACT, a division of the Greater Washington Educational Telecommunications Association.